Heyo, heyo, heyo. Oh, yeah, that was interesting. What's going on here? Settings. Camera. Why is that on 480? Huh? That was weird. Okay. What's that? Touch up my appearance. I have no idea. Do you see anything difference? This is... No, don't. I'm good as I am. All right. Welcome back. Yeah, this was interesting that the RCD or RCDS went out and troubleshooted. Everything worked here. So everything, okay. Walked out to the circuit breakers in the barn. And one of the fuses there out. But that shouldn't affect the house. No, they are connected. Hi, Farrell. Hi, Christine. Hi, Mike. Hi, Sal, Sunny, Heather, and everybody else. Even though the fuse boxes in the barn and the house are connected, that shouldn't happen. So that is really strange. But that is a tomorrow problem. I changed the fuse, and everything is up and running again. So it doesn't seem to be a big problem, at least not for now. Yeah, what else have I done today? Today I went to a little swap meet, or whatever you call it, and I got myself one of these. Because I drink a lot of coffee. And having that little... Hi, Jingles. Jingles is here. Yeah, and for you who don't know, let's see, where did I put it? I made a little something. I made... this. Yeah, and let me find it's on Teespring. I have it in the community section on my page. So yeah, and it's ready for purchase, and it should be at your place around before Christmas. Should be. Because their Teespring has manufacturers in Europe and in USA. So it should, no matter where you are, you should have it before Christmas. And I think I put it at $12. So I make $1 per mug. Yay! Got a rap ad. Oh. Oh, that's funny. Yeah. That trial is going to last 3 weeks of young. Oh, Christine, this trial is scheduled for 6 months. Yeah. So yeah, we are going to have fun. All right. Yeah, Young Thug. And yeah, today we... Okay. Ow. Hello, Dingles. Yeah. Young Thug. Today we are going to watch from yesterday's hearing. and that stream went down on Law and Seaward because the judge got upset about something about the positioning of the defendants. I have no idea. So more or less the entire morning disappeared, and I don't see it being up yet, but we are returning after lunch and after the debacle, so to speak, is done. So let's see here. Share screen. Big screen. Better sound. Add to stage. There we are. Hold on. There. No, not that one. No, definitely not that one. Where is it? That one? Yeah, sure. And there. Okay. So I don't know where they are in the motions hearing, but I hear it went well somewhat, but I don't know how. So let's just go right into it. Good morning, Melissa. Yeah, 3 weeks of sidebars, maybe.
Why is it going? You're going a while. Play by play.
All right, devices. Yeah, it's fine. Yeah, yes. And I'll let you test yours in just a second. Could I have all of our accused put the devices on, and then counsels? I'd like you all to come to the bench. One lawyer per. Yeah, it's gonna be blocked. So all of you, we're just gonna practice. Y'all can come up in front of the bench.
You're not that late, Sardonisms, because I had an incident here and my power went out.
Lawyers, you don't need one of these, okay? Only for Let's just do a check. Up front, so I can go ahead and take, we can go ahead and put our jury out and take the matter up. But for routine things, this should suffice in satisfying the Sixth Amendment guarantees. So anybody have any questions about the devices or have any other comments? Okay, we good? All right.
Yes, sir. Thank you.
All right. Anybody else? All right, does everybody else field tested them okay? You're good? All right. And they'll be charged daily so that we can go ahead and they'll be ready for use. What you got here? Okay, cool. Thanks. Okay. All right, let's talk about, that's the technology. I wanted to go make sure that works so we could record and we could go ahead and make sure that everyone's could participate in bench conferences. All right. Okay, let's talk a little bit about the configuration. So did you all talk with Captain Kendall and the pendency? So what was the last, are we good? What other suggestions do we need to go through?
In terms of the seating arrangements, Judge, I
suggested location for each particular party, taking into account how many attorneys and client for each party. So I think we're good. Everyone appears to be in agreement.
Where did Aaron go?
For the future trial.
Can we get him back? Do you have his number, Tim? Okay, yeah. I had a question about, there's another camera issue that I wanted to kind of explore as well. So that's why I wanted to call him back. Okay, so we good on configuration, folks?
I believe we are.
Okay, so we'll get, we'll probably need to have Captain Campbell come back down to our name room. So we can make sure that we have all the skirts and everything else put around the tables and the other things that are, the configuration. What was your discussions about anything in regards to the center, of the courtroom?
Judge, we did not have, at least the parties didn't have any discussion about the center. Captain Kendall believed that's totally up to her. That has to do with the general public and family members, believe that up to her. In regards to the jury box and the witness stand and the visibilities, we've talked to Captain Kendall about the possibility of that witness stand moves, it actually rolls. We looked at some video photos from the APS trial. We're moving forward.
Okay.
That will give greater visibility. We'll be able to see the witnesses from over here a lot clearer. We've talked to them about moving the screen to the side where you see it right now, so it's not in front of them blocking the.
Yeah, that'll work.
Ms. Weaver is fine with only having one entrance and exit. But we'll move that forward. She'll be able to block from going out on that side. I think Captain Kendall indicated in regards to tables, she get a table, she get skirts, she's rounding up chairs, we should be fine there. Everything should be uniform in that regard. In regards to jury box, the last row over to my left.
Closest to the windows?
Closest to that wall, yes, sir, to the window pane wall. We will not be using those seats.
What do you mean, what's up with the audio? Is it scratchy or anything? Is it going up and down? I don't know. I know we hear the judge really well and the lawyers really bad, but that's in the stream from Law and Seawood. Good morning, Tracy. Oh, ow! Yeah, Jingles is running the show here.
And so if all the jurors sit from second seat over, with some additional seats in front of the bar, that should, we should all be able to see the jurors, they should all be able to see us.
Great.
There are two chairs in that jury box that needs to be repaired. I think Captain Kendall on top of that.
Yeah, we have a few more days. The jury room has been painted. We have a new configuration that will hold all of our 18 chairs, as well as comfort items for our jurors.
I think we're fine.
Okay.
I think we worked it out at least.
All right. Okay. All right. Anybody else have any other? I'm going to have Captain Campbell come down, and I'll figure out the center configuration and talk with her about that, so that there are no evaluate the 17. Okay, let's talk a little bit about the witness list. Did you all talk independently, Ms. Love and Mr. Steele and others?
We missed one another on the break, but Mr. Steele was able to approach me right before the court began the most current session. And I'm looking at and amending the order, making just a couple of changes. Mr. Steele has indicated he has no objection to any changes that I see necessary that don't materially alter the request itself. And I'm making those amendments, and I'll send it to him and then present it to the court for the court signature. There is one question that I had.
Yes, ma'am.
I wanted to make certain that the order gives a time frame within which the CHRI shall be provided. I said 72 hours, no more than 72 hours. I will let Mr. Steele make that request of the court so that I can put it in here.
What did your contact with the GBI?
The trial starts Monday, and she needs 72 hours. That was Tuesday. That Thanksgiving for you. I mean, they really, really don't want to give the defense any heads up whatsoever.
Indicate that was feasible.
September 22nd of this year, he said that they could probably get that information within 2 to 3 days. That was the way that he put it, and that's why I said within 72 hours. Or they shall show cause why it's not provided.
Okay. 72 hours sufficient, Mr. Steele?
Of course.
Okay. All right. How are they supposed to be, the records supposed to be transmitted?
That is the other thing that I indicated in here. So I said that they shall be provided no more than 72 hours from the date of receipt of this order by GCIC and GDI, and shall be provided to Mr. Steele at this address and email address in any permissible manner provided by law. So if they're allowed to send an encrypted email and Mr. Steele has no objection, or if they make them available for him to pick up at a physical location, I don't know the manner that they provide CHRI. So if there's a manner the court wishes that I designate, I will include that as well.
Did you happen to ask your contact there, what's the preferred, what's the fastest medium, or what do they prefer? Just so I don't get cross purposes with the order in terms of the distribution of those paper records.
I did not ask.
Can you call him and find out? I mean, because I think 72 hours is fine. Mr. Steele, do you have a preference? They're sensitive records, but I think all of you are, basically as officers of the court.
They are talking about the witness list. And we found out last week that the state have 737 witnesses on their list. They had added on between October and now 105 witnesses, and from August to now over 300 extra witnesses. So and this is them giving the witness list to the defense in a proper manner. Yeah, I'm gobsmacked. Absolutely gobsmacked. That the state still makes every effort possible to not give anything to the defense.
So yes, Your Honor, I will call him, and if the court allows me to do so on the court's next break, unless you want me to break right now.
If you could call him, just give me a minute, and maybe we can take a few minutes out, and you can I'll just recess in place and let you call him.
Okay.
Okay, did you all talk about the list of witnesses?
Yeah, this is the latest witness list. I think they have everything but the last 105. So it's more or less those they are talking about, I think.
To begin with, in terms of, is there anybody that needs to be interviewed, to be made available? Did you all get have conversations in regards to specific witnesses or people that you wanted to interview?
Your Honor, may I speak?
You may.
Okay. The state did give us a list of witnesses that they're going to call the first several weeks. And I highlighted on the list, except to the state, people who I have not spoken with or who have not refused to speak with me. So,
How many people are we talking about?
about 40.
Okay, I'm going to ask that. Does that represent everybody, or is it just Mr. Williams?
That's everybody. That's the.
Like all defense attorneys, all 6 of you, does that represent 40 witnesses you all need to talk to, or are there others?
I need to, during that rest in place, if you don't mind, I need to.
Because what I'd like to do is, I would like to identify those witnesses, and then what I'm thinking about at this point in time, counsels, is
Yeah, but that should it be dismissed? Maybe, but not with this judge. This is I'll allow it kind of judge. Yeah, they had that hearing last week, and the judge approved it because there will be time during trial, since the trial is going for what is it, 6 months, that as long as they get a heads up before they actually call the witnesses, so they can conduct an interview during the, yeah. No, I agree. I don't even care if they're the guiltiest guilty of the guilty. This due process regarding RICO trials are unnervingly bad. Hi, Brandon. Yes, this is a RICO case. This is the Georgia RICO Act in play. The prosecutor is Fanny Hill, or whatever her last name is, and that is the same prosecutor as in who is indicting former President Trump. Oh, they have standing objections and appeals right and left regarding a lot of stuff that is on the way up to appellate court. But that will be handled during the trial. Some of these motions to dismiss, if the appellate court sustain them, trial's over in the middle of the trial. But yeah.
Just for your planning purposes, to go ahead and from like potentially the 18th of December, the 18th to the 22nd, and possibly the 27th through the 29th, for you all to come up with a schedule to go ahead and either interview those people via Zoom or live, but I'd like to see a schedule. And that would be my suggestion on the time. That would give you, I think, sufficient time to interview any of those witnesses during that particular period of time. But I'd like to see a schedule, a proposed schedule, that you all can come up with, so that, and if I need to be available, I can be so remotely or whatever, but it would be my intent for you all for that particular period of time.
Yeah.
As we talk about scheduling, I am going to tell our jurors day one, they'll probably from the 18th to the 22nd, they will be, that'll be our pause to give them and everyone else an opportunity to get ready for the holidays. So to the extent that you all can take care of business, that would not interfere and would not slow down our jurors. So that's what I'd like to do at this point in time. So just so you all can kind of get ready in that respect.
So, Norman, may I just make sure I heard you, I went out for a second.
Thank you for offering your help, but I have everything set for this trial. Thank you for offering.
But you're saying starting the 18th, the court will allow us to interview on Zoom or whatever.
Yes.
Zoom or in person from the 18th.
All right. We have visitors from Jeff. I will send Jeff an invite. Hey, welcome Legal Vices Raid. Yay. Hey, Flux. Hey-oh. I'm going to send Jeff the link. Dun, 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 where? All right. Jeff dropped us off for the weekend. Oh, yeah. I booked up my entire 2024 with the Young Thug RICO trial. Definitely. Hello, everybody, and welcome. Good to have you all here. What we are watching is one of the final pre-trial motions before the Young Thug RICO trial starts next week. They are currently talking about the witness list of 737 the state plan to call. Yeah. And they are now discussing the final list of 105 extra that the state produced weeks before the trial starts. And it was allowed by this judge. This judge seemed to be an I'll allow it kind of judge. Hey, thank you. Thank you, Jeff. Hey, it's 2 a.m. Yes, hit like, subscribe, you know all the drill, and everything. This is a part of my Young Thug week. I have had streams Monday, Tuesday. This is Wednesday. Thursday or Friday, I am going to make dramatic reading of Young Thug lyrics. So that is, yeah, you have. So if not for anything else, you're going to need to. You are going. Yeah, I'm old Thuglet. Oh, yeah, that will be amazingly fun. Hey, Brandon. Brandon has been a member for 6 months, and which in baby terms is 3rd trimester. Yay! Now, what they are discussing here regarding interviewing witnesses on December 18th and 22nd, yeah, that is after the trial has started. So this judge, instead of allowing the defense to interview them before trial starts, he said, you can do that during trial, instead of telling the state, this is too late, get them the F out of here. No, he allowed it. So 737 witnesses. Half of them expert witnesses, half of them layman witnesses. They have vacuumed the state of Georgia for this. Brandon, upgraded membership to a Viking Raider. Yes, I now have 2 tiers. You are a Viking saying hi or a Viking Raider. And I'm not entirely sure if there's more new stuff. But, oh, I have to make, there's a cat emoji if you become a member. And a Jingles emoji. And if you don't know who Jingles is, that's Jingles. I made that today. It's Viking Jingles in court. What did he do to need all that? Become a member? No, this is a RICO trial. The entire YSL gang was on trial, is going on trial. They were 28 in the beginning. They are down to 6. Most of them have pled out or been just removed from the case. So there are 6 remaining. And the RICO trial means that every crime from every part of that alleged gang, everybody is on trial for it. And these alleged crimes was conducted between 2012 and 2021. Yeah, something like that. Oh, me, I am, on a good day, I'm 6'4". But there is where we are in this trial. So sound is a bit sketchy. The judge is amazing, in sound at least. The lawyers have an allergy towards microphones, as per usual. But, ta-da! Oh, and yeah, this is in Georgia, a RICO trial. It's the same prosecution that indicted former President Trump. So what you see here is indicative of what President Trump will go through.
To the 29th of December. That would be your period of time. And so that's why I want to get a list that we can go ahead and then you all can,
Yep. This is Fanny.
by the 20th, but by the 27th, the time we come to do opening statements, that's when that list needs to be finalized in terms of what dates that you all wish to interview these particular witnesses, what method and manner means, what just kind of like a discovery schedule of witnesses, just so you know what dates and times and that you've been able to kind of contact people and that they will be available or make themselves available.
Thank you so much.
Okay? All right. So we still got to get that done, but if you would, next break, we'll go ahead and at least identify those people. We'll modify the order to the GCIC, GBI, and get that started. Okay.
I also have an answer for the court.
Oh, great.
In looking at the correspondence that I have with legal counsel, he did indicate that requesting the information be returned via email instead of USPS allows for the quick turnaround. And specifically back then, he had said, per GCIC, allow 5 to 10 business days for processing. However, when there is no backlog, which is currently the case, it will likely be closer to 1 to 2 business days. And he said then.
Okay. All right.
So I will include in language in the proposed order that CHRI shall be reduced and made available via electronic mail or any faster means of delivery.
Okay. Mr. Steele, you want to be the point person for that, or do you want, or how would you like dissemination to be done?
Email to me is fine if it's okay with everyone else. I promise everybody in the court, I will get it to everybody.
All right. Mr. Shaw, you okay with that?
Yes.
Mr. Weinstein?
Yes, Your Honor.
Mr. Harvey?
Yes, sir.
Mr. Matthews?
Yes, Your Honor.
All right, what about you, Mr. Williams? Okay,
Will
anybody else on this? Okay, all right. Okay, now that I have Captain Kendall back with us, Madam, what can we do about configuration in the center portion? And thank you for your work with council to go ahead and make sure that everything's kind of line of sight. They told me about the jury box, and I'll need to remind our jurors just to fill up. And I'm sure your colleagues will probably do the same. That we'll not use those last 3 chairs closest to the wall. So and everybody else, and then we'll have suitable seating up front. So, what can we do? Yes, ma'am.
Can I just say what I'm talking to?
Yes.
Yeah. If you have social media, I wouldn't mind you if you share the
Starting
link.
room is Aaron on his way back.
He's supposed to.
It's flipped upside down.
Hey, can you have Aaron come back? Okay, thanks. All right, bye-bye. Oh, are we getting those other 2 chairs prepared, or do we need to follow up on that? Which chairs need to be?
The chairs are prepared at 65 and 73 on it. I've already did the work order on them.
Okay.
Then when the ring has somebody come in, it seems to be another break.
Oh, excellent. Okay. Excellent. Okay, all right. Madam, okay, so how many benches can we put back in the centerpiece of this courtroom?
How many are back in around?
As many as possible that would be consistent with seating and security.
Can I ask the reason to have them replaced, John?
Say again?
Why we want to replace?
And as per usual, law and Seawood. Oh.
Mr. Harvey segued into a matter that we had not been previously discussing as it relates to victims' access to the courtroom. So Mr. Nichols' spouse is not a victim.
No, he's segued into another. It's his third portion of his objection about related to whether or not Mr. Nichols' wife is excluded from the rule of sequestration or exempt from the rule.
And I say that because 1779 subsection B talks about shall be exempt from the provisions of code section 24-6-615 regarding sequestration. So
That's a victim of criminal
I
offense.
know that.
But that's
Plays into the rule of sequestration.
but she's not a victim, right?
I I'm not.
She's not a victim.
She's not, I'm just talking about rule sequestration.
Okay, so, all right, we can park 17.9. Okay, so, all right, so does she fall within an exemption to the rule of sequestration?
If she invokes the privilege, she cannot be a witness and therefore is able to watch the trial.
But we don't know that until she's called, right?
No, you'll know that beforehand. She can formally invoke and say, hey, I refuse to testify.
I don't think it works that way. I think it depends upon when she's being called as a witness. So until that particular, and you haven't asked me to rule upon that till now. So, I mean, usually it's when that witness is called that I make that decision.
Alan Walsh, I have everything set to, because I can just monetize and then ads. And the only thing I can control is how often ads are played. And I have had every 30 minutes because that's the longest I'm allowed to set. I'll show you. Hold on for a second. So the rest is here. Every 30 minutes. Because I don't have a choice. I know some people can get away from it. I can't for some fucked up reason. Yeah, but and I wrote to my handler on YouTube and said that I don't want ads in my streams because I stream trials. You can't just have an ad in the middle of some. Imagine if in the middle of reading the verdict there's an ad. I mean, seriously. So if I want to be monetized, they force me to have ads, but I'm having it as seldom as I can, and that's the only thing I can. That's the only thing I can do. Sadly.
Or she's exempt. So I guess you're asking me whether or not we can make that ruling now.
Well,
But in order for me to make that ruling, you would need to have Ms. Nichols here and Ms. Kaufman for me to kind of make that particular,
I agree with you. I'm giving the court a heads up. I believe you can move her prior to the trial so that she is able to watch the trial.
Mr. Harvey, we're going to start at 9 o'clock or 9:30 on Monday, the 27th.
I didn't say that.
Okay, all right. So if you have Ms. Kaufman here on Monday, I can make that ruling at that point in time.
Thank you.
And Your Honor, whenever the court deems it proper, we will present the state's argument to the assertions Mr. Harvey made.
Why don't you tell it to me now, since if you have it.
Yes, Your Honor. Okay.
Yes, Your Honor. In looking at 24-5-501, it is a community.
5-501?
Yes, Your Honor.
503.
Yes. So first, Your Honor, you have to determine what is privilege, and it's communications between the husband and the wife. So what them two talk about specifically, Your Honor, and I don't believe the state's testimony is going to elicit any communications between Mr. Nichols and his wife. The testimony elicited will not be communications between the spouses. And so therefore, I'm not sure if Ms. Lewis, for that particular purpose, will fall under that privilege. But I want to look at 503 as well, Your Honor.
Yeah. The state wants all the leeway, including having testimonies from the wife of one of the defendants.
And I believe, Mr. Harvey, you're looking at 503A.
there's been so much weird going on in all of these motions. And if you go back a few months when I covered the Daubert hearings of the experts, their experts are crap.
Your Honor, I think we will just need for Ms. Lewis to come before the court. We would just need Ms. Lewis to come before the court with her attorney.
I'm sorry.
We would need Ms. Lewis, Shantisha Lewis, to come before the court with her attorney.
Okay. What's going on now? Yeah, the experts in this trial so far of the Daubert hearings I've covered, at least 1/3 of them, I have nieces better at technology than some of these. They have a pinch and zoom guy as an expert. The state wanted that guy in as an video analyst of sorts. And during the Daubert hearing, we got to know him and what he does for a living. And what he does for the police force is that he gets the video, he pauses, he takes a screenshot, take that screenshot over to Photoshop and enhance the thing the cops want enhanced.
Is Ms. Kaufman available?
Checking right now. I think she is out of town through Monday, but can we, no.
Like, I won't be able to rule until such time as, but I can do it 8:30 on Tuesday, Mr. Harvey.
No, that pinch and zoom guy is a former FBI agent, and that was his job in the FBI, where he quit 1992. Since then, he's been working for the Georgia police as a video enhancer. They send the films to him. We want that part of the video enhanced. That is what he has been doing for the past 30 years. And I bet he makes good money from it as well. I didn't know you can have a job doing pinch and zoom.
Okay.
I mean, it's good, yeah.
Yeah, it's because you get
It's
it one
not
time.
like-
Given that you told me the last minute, so I mean, I could have ruled on this earlier, but Tuesday morning. Can she be here at 8:30, Mr. Harvey, on 28th? Okay.
I'll let you know.
Okay, all right. We'll follow up on that.
Hit that thumbs up. You know, from you came. Most of you came from Jeff. You know what your job is. Hit that thumbs up. Get me through the YouTube algorithms.
Okay, bear with me a second, please.
120 people watching. I should have 100 likes. Ah. For a bit. Thank you. That is Jingles, and it's my farm cat.
Okay, folks, let me take up a couple other issues that that have remaining on my list of things to otherwise cover. Mr. Steele, I just so you know, it's still kind of it's still out there. On the 24th of April of this year, we heard the motion Dauber hearing to qualify Mr. Adam Dunbar. As you recall, I deferred ruling on that until such time as I heard I was going to need to hear lyrics. At this point, I think I'm still in the same position at this point in time, meaning that depending upon what the state presents, then I'd be in a better position to finally rule upon that issue, consistent with what I said on the 24th of April.
I understand, I won't mention it in the
Yeah, I just want to make sure that you knew I'm still defer ruling on it, but I need to hear, and then I'll ask you to invite my attention to revisit that once that we've gotten to that point, and then I can make a ruling on that issue and let you know where you stand with that, or if it needs to be recalled, consistent with further Daubert Foundation, I can do that. Okay?
Yes.
Okay. All right. The second issue is on the 2nd of June of 2022, there is a motion to disqualify Mr. Steele and Mr. Sharp. I heard that motion. I did not disqualify either one of those two counsels. We went through an extensive waiver process, and as it stands right now, the court's earlier ruling and concerns will in fact stand. I know that the state said they had additional argument on that issue. Depending upon, there was some talk that you were potentially going to call Mr. Steele as a witness. So I just wanted to revisit that at this point in time. So, Ms. Lover, Ms. Hilton, what say you in regards to that?
Yes, Your Honor, I will be addressing that.
Yeah, this has also been ongoing during the pre-trial motions and everything, that the state, if they're not happy with the defense lawyers, they try to get rid of them. This case is a complete cluster F, completely. And the judge even entertaining this is mind-boggling.
Hold on a second.
Your Honor, as it relates to Mr. Steele's ability to represent Mr. Williams in the trial of this case.
Use the
At this time,
microphone,
Judge,
lady.
we have sort of two categories of potential conflicts. One, an actual conflict that, should arise at trial, and now we are in the category of potential conflict. We have the records where, or at least we alluded to the instances where Mr. Steele represented multiple defendants who are now on trial or either awaiting trial in this case. And if the court sees or finds that essentially he is a lawyer for YSL, then that particularly would be a conflict. However, at this time, Judge, we defer to the court's findings and rules.
Here's the thing with one lawyer representing more than one client here. Is it good? No, not especially. But the state had 28 defendants at the start of this. They are now down to 6. Many of them have pled out, but there were a handful of the 28 that didn't get counsel for over a year. So they were held without bond for over a year because there were no defense attorneys available for them. And that is the state's doing.
That the court is inclined to make at this moment, where a potential conflict exists, and we do not.
In August, it was said 6 months. Since August, the state has added on over 300 new witnesses. So more than 6 months would be my, and I will be covering this trial gavel to gavel, either live, recaps, or videos. But you will get, if not daily, at least a few times per week, either streams, videos, or live recaps. The entire first week, next week, I will cover live. Yeah, they are up to a total of 737 witnesses.
Have an actual conflict unless the court determines that Mr. Steele is the group's lawyer, the go-to person, and I believe that that would be governed by United States versus Castellano, or at least not governed, but at least it is instructive. And the site for that is 610F and Frank Sup 1151. And United States versus Pizzonia, Pizzonia, 415F Sup 2D 168.
They are accused of having a criminal organization under the Georgia RICO Act, which means that every person in that gang, if that jaywalks, then everybody is guilty of jaywalking. If it is a homicide, everybody is guilty of that homicide. That's the Georgia RICO Act. And these alleged crimes has, according to the state, has been going on between 2012 and 2021. Here's the thing. An example, an ending that happened in 2014. Then the state did not have evidence to even charge the people they now are charging under the RICO Act for murder. This tells me that the state is going guilty by volume. Look at all these crimes. I think they have 190 charges. Look at all these crimes. So they were too bad at investigating, too idiotic of a prosecution to get them on the individual crimes. So now they're doing it under the RICO Act in hope that the sheer volume of crimes and allegations will be enough to get a conviction, in my opinion.
One moment now. As we alluded to in our motions hearing regarding the lyrics, our records reflect that Mr. Steele is currently attorney of record for Mr. Damone Blaylock in 19SC168236, a case that is currently open. Mr. Blaylock currently awaits trial in this case. He has been severed from this particular trial. Mr. Steele was counsel of record for Mr. Blaylock in the motion for new trial hearing held on September 22nd, 2023. Additionally, Mr. Steele is counsel of record, to the best of my information and belief, for Mr. Quantavious Creer in case number 10SC92020, which is currently on appeal and open. Also, our records reflect that Mr. Steele represented Mr. Martinez Arnold in 14SC131032, which I believe is one of the overt acts that are listed in this indictment, wherein Mr. Steele communicated with officers and facilitated Mr. Arnold turning himself in. Mr. Steele, to the best information and belief that is available to the state represented Mr. Quintavious Greer in case number 20SC176971, which is now closed after the charges were non-prossed by the district attorney's office. Of course, the court is aware that Mr. Steele is representing Mr. Williams here before the court currently. And we also reflect that Mr. Steele was the attorney whom Mr. Stillwell sought to retain when Mr. Stillwell was arrested for this indictment. However, due to a financial issue and the ultimate arrest of Mr. Williams, Mr. Stillwell was unable to retain Mr. Steele as his counsel. So, and the court did hear the proffer made by Ms. Hilton regarding the arrest of Mr. Stillwell and the incident and the acts that occurred during that time. I believe that Mr. Steele may have been called on the scene and may have advised Mr. Stillwell to say nothing. But this is the information that we feel is pertinent to the court's determination as to whether or not Mr. Steele is qualified or that there is no conflict. And
is there anything new that I did not hear back? I mean, because I heard Mr. Steele was represented by Mr. Bullard at that point in time. I did hear arguments from Mr. Geary, Ms. Rosenwasser, and Mr. Smith on this issue, and I ruled based upon those particular those arguments and the cases that were presented to me at that time in regards to Rule 1.7 and just wait 1 second. I'm sorry. And and the consideration of 3.7 lawyer as witness. I considered at that point in time the cases of
I don't know.
Bernucci versus Forcucci, and that's BRNOCCHI et al. Versus Forcucci, and that's FORCUCCI, decided by our Supreme Court at 279 Georgia 460. I consider United States versus Harrison, which is a not reported case, at 2005 Westlaw 1863331. I also considered Henry Robinson at 90 Southwest 3rd 921 2002. I also, among others, and to include the rules of professional conduct. Should say 1.7 and 1.7 and 3.7 lawyer as witness. So is there anything else that, I mean, I've made rulings consistent with what I heard at that point in time, but is there anything new? And I guess that's the first question. The second question is, are you intending to call Mr. Steele as a witness? Or are you going to make that decision later?
Your Honor, at this time, we do not intend to call Mr. Steele as a witness. There may come a time when that
could happen.
And I just want to be clear, the only matter that I just wanted to make sure that we addressed was those instances where either if the court decides that based on Castellano and Pizzonia, that Mr. Steele is a representative for the organization group itself that we allege is YSL, then I'd ask that the court make certain that is considered. And
for me, this should have been handled long before. And as the judge just said, back in April, if there are no new arguments, then he will deny this motion. Because, what if something happens? Well, then you have to bring it up on new motions if something new appears, because this is just moronic.
And in terms of actual and potential conflicts, if Mr. Steele is representing Mr. Williams and has to cross-examine someone, for instance, Mr. Greer or some of the other persons that we have named that he represented, he has and he owes an obligation to Mr. Williams to use everything that he has to advocate for Mr. Williams. And that would include perhaps access to information that is privileged as between Mr. Steele and the other witness.
And that's why I indicated to him that he may have an actual conflict at some point in time, depending upon how the evidence is presented and plays out.
So we don't have new
Okay, all
information.
right, just want to make sure. All right. Mr. Steele, you wish to be heard if it, all, sir?
And I heard what the court said, just manage to collect the records, but otherwise no. I just want to make, it's the same exact thing that you heard in June of 2022, but I just want to make sure that the record is correct.
May I do that, sir? Yeah. Okay, Mr. Damone Blaylock, I do not represent him on this case. As the court may remember, the Honorable Justin Hill represents him. I do represent Mr. Blaylock on pending motion for new trial. As far as Mr. Greer, I am not the current lawyer for Mr. Greer. This honorable court signed the withdrawal. He's represented by the Honorable Nicole Fagan on his pending murder case. I did represent Mr. Greer on his, I did not represent him in trial. I represented him on appeal. He won that appeal. He reversed the murder conviction, and then Nicole Fagan is his lawyer. He did have another case. He was arrested while that appeal was going on, Your Honor, with a gun, allegedly with a gun. And I did do the initial appearance, and I showed the honorable court, it was a magistrate court, that conviction was set aside. So he was not a convicted felon. That's why the case got no process. That's all I did on that. What did I say? Did I say Nicole Fagan? Nicole Mormon. Thank you. I apologize, not Nicole Fagan. As Mr. Arnold, I never represented Mr. Arnold ever. And that all came out. I did make a phone call as a courtesy to the police to see if they wanted him to turn himself in. I did not ever speak with him at all. And then I was done. He had another lawyer, and that lawyer was Mr. Edward, what's Ed's last name? Yeah, Ed, thank you, Edward Adams.
Ed Adams.
Yes.
Okay.
Mr. Stillwell, he did call me. It's not the way Ms. Love thinks. It's not because Mr. Williams was arrested on May 9th, 2022 that I did not represent Mr. Stillwell because of money. I wrote a letter to the state VA's office to the Honorable Kara Convery on March 24th, 2022. I can enter into the record if you like, but saying that I'm not going to represent Mr. Stillwell. That's a month and a half before Mr. Williams was arrested. Thank you, sir.
Okay, all right. Mr. Steele, I'll just kind of, reiterate the fact that while you are Mr. Williams' choice of counsel, I have all the waivers that we went through that extensive process, but that, any of your colleagues who may have cross-purpose, because each one of you represents your own entity. So at such time, if that becomes an issue, I'm going to have to revisit the issue of disqualification at that point in time. Or if the testimony develops that causes the state to revisit the issue of whether or not there's sufficient good cause to call you as a witness, then I'll revisit that pursuant to 3.7 and the cases that have been cited. But at this point in time, I just kind of tell everybody that matters in flux and in stasis at this point, but that I'm satisfied as to where we are at this juncture. So I basically deferring any further ruling until such time as it becomes necessary. Okay. All right.
Okay. That was somewhat resolved, I guess. But as Ashton said, it's very common for many attorneys to represent for different defense attorneys to represent an accused over the years, especially if they don't have money and they are always contacting the public defender's office, or if a lawyer there then becomes into private practice, stuff like that. So, yeah, for me, I agree. The state is overinflating potential conflict issues. If there comes a time, because they have been trying to disqualify Mr. Steele since April, unsuccessfully. And
Mr. Steele, these motions were filed by you. These are Mr. Wayne's motion for the preliminary number 37, 36, and 37. Filed as of the 20th of November, after the deadline I set. It appears that you are asking this court to exclude several pieces of tangible evidence. Did I make some rulings on this already? I was going to ask you, did you ever get with Ms. Love or Ms. Hilton or the state to kind of determine which of these particular items would fall within the category of, or may fall, or could fall within the issue of derivative evidence that would not be subject to being called?
So, yes, I put it all in writing and and I was specific, and I was specific in the motion. I can't remember.
No, but I asked you
36 or 37.
I asked you all to get together in that respect.
Well, I think-
Because,
okay.
I mean, because here's the thing. I'd rather have an order as opposed to a motion, because I've already ruled on that. So I was going to ask, I was pretty clear, I think. I asked you all to sit down and take a look at whatever came as a result of the search of the house, whether it was, or that was basically taken, and come up with a list of tangible things that need to be excluded. So that's kind of what I'd like. I'd like you all to kind of get together and have an order made so that I can go ahead and do that. Because anything that would have been seized at that point in time would be subject to being not called or not used in this particular, from the court's earlier order.
Understood. And the only reason I just want you to know I was.
No, I think that's improbable that they are somehow in collude. It's just that it seems like this judge is he's very fast with handing out contempt of court, but other than that, he's quite weak in rulings. That he seems to be, if the defense can't show clear-cut case law without any interpretation in the state's favor, then he goes for the state's suggestion. So he's, yeah.
Trying to go against your order, but November 20th, that's when the discovery was read by me in total. So then I could figure out what is derivative evidence. That's how I got that. And then I footnoted where I found everything.
Okay, so is that something that you and Ms. Love can
Yeah.
sit down and do? Because you recall, Ms. Love and Ms. Hilton, that that's what I had asked you all to do. I don't think that's something in the many things that you all were supposed to do that ever got done. So I need an order on that particular issue. And that would satisfy motion in limine number 36.
I will, there are proposed order that I will meet with Ms. Love, sent to Ms. Love and Sully. If they disagree, we can discuss.
All right.
If Mr. Steele would hold off on providing it to the court until we had a chance to communicate with one another, I think that would be maybe more efficient than if we're trying to consider the order.
That's fine. But that's fine. But you all need to have that. I need to have something by Monday. Okay. Okay. All right.
Judge, I am almost done. I'm going to send this data over to you.
That's fine. I'm going to give you all a break in just a minute. What about Mr. Steele? Motion limit number 37. I believe that covers any uncharged misconduct. That would be much akin to improper 404B or 404A.
Yeah, that's right. So these are all the state is alleging, Your Honor. There are other acts in 418 evidence and
That was going to take up the 418 issue next. So
I just grouped them together, and they were saying intrinsic. I don't believe that most of these are intrinsic. I don't believe 418 will apply when you look at least for Mr. Williams, his gang count. So 418 only goes to the indicted gang count. Mr. Williams only has 2. And then the other ones are 404B, which we need hearings on. So all I was saying was please don't mention anything that's not charged unless this honorable court approves it.
because I've ruled on it.
Exactly.
All right. What's the state's pleasure on that issue in terms of? I haven't received any notices on 404B. I don't think. I do have the 418 issue to take up, but
The state's position, Your Honor, is that the matters that we have noticed counsel for the defendants that we intend to introduce evidence of at trial are actually intrinsic. They are part of the proof. They are overt acts that are not outlined in the indictment per se, but they are overt acts that tend to prove, and we will argue at the appropriate time, tend to prove the defendant's tacit agreement to participate in this particular enterprise through a pattern of racketeering activity. Your Honor is correct. There are no 404B motions pending before the court. We do not believe that this other act evidence would properly fall under 404B. We, again, can fully litigate it, but It also includes acts that the state does not allege were committed by the defendants on trial, but rather acts that were committed by opposition, gang members. I spoke briefly with Mr. Steele about this at the start of today, and my understanding is that defendants are opposing the introduction of that information as well. So at whatever, did I say that wrong? Okay. I retract that because I don't want to misspeak for anyone in this court. So we are seeking to introduce evidence of other activity that we believe is intrinsic to this case and to the conspiracy that is alleged in 22 SC 183572.
Okay, it might be appropriate for me to take up the 418 issue. So let me go ahead and I know you all filed a
We did.
motion to that effect.
And because I am preparing this order that I'm going to get over to Mr. Steele, I would ask the court's indulgence for about 10 minutes. If I was.
All right, I was going to say let's just take a recess until till 3 o'clock. We'll come back.
That's
Okay, and then you all can consult and confer. And then I'd like to take up the 418 issue.
Yes.
Okay.
To the witness list.
And they are back.
Yes, Ms. Love.
I just sent that to Mr. Steele, for his review. We just discussed it. He's okay with the closed order. We're gonna populate it. In short, what the order is requiring GCIC to do is to provide in 72 hours the criminal history record information of the person's name in the order. We have on the original list given to us by Mr. Steele some, I believe, professional witnesses. I have asked one of our legal assistants to go through that list, take out professional witnesses, law enforcement officers, things of that nature, and to include on the list first the witnesses that we have provided last evening as the first 3 weeks.
It's around here somewhere.
And then in order based on our projected trial structure.
Okay, can I get that in short order, like in the next 20 minutes?
I believe so, and I'll,
Because if you all could print it, I will sign it, and then when you can e-file it, and it can be transmitted.
okay,
Okay?
yes. Yeah, and what I will do is also send it personally to the gentleman that gave me the directives in the first place,
All right, okay.
so that it can be considered received by them.
Okay, all right, so we'll do that. Okay, based upon the other issue that we had, just kind of make sure I have my notes.
Thank you so much for the donation via PayPal. Thank you so much. This is not the name you are using in chat, but you know who you are. And thank you so much. It really helps keeping the channel afloat and improving with, thanks to you, I got a new microphone. I had bought this new computer. So next step will be to get a better camera. And yeah, what's going in through PayPal is going towards building a studio. And so I get out of the house because I want to smoke cigars on stream too. And I don't smoke cigars indoors. Thank you so much.
Okay, sorry. Okay, thank you.
Through here so we can hear when they start.
Your Honor, Mr. Steele has suggested.
Okay, here we are.
And Your Honor, Mr. Steele has suggested, and I would ask the court to have this order filed under seal, considering it has identifying information.
I don't have any objections, Your Honor.
It can be filed under seal. Yeah, in fact, that probably preferred. So let me, if you'll, I'll sign the order. You can transmit it and we'll file it under seal. You'll need to give me a sealing order, Ms. Love. Just make sure you run that by Mr. Steele, okay?
Okay.
All right.
A lot of downtime. Regarding Mr. Jingles, I hear the cat door when it opens, if he's in or out, and I haven't heard it open, so he's somewhere in the house.
I'd like to, on the 1st of December, that's a Friday, after Thanksgiving, for you all to have met and for you to tell me, I'm going to inquire about it on probably on Wednesday, the 29th of, but I'd like to by Friday for you all to have an actual schedule of, and that should give you the better part of now to set up appointments and schedules with those witnesses that you wish to go ahead and interview. So I'd like to see a schedule either via Zoom or in person, it can be here at the courthouse or via Zoom. And that can commence from the 18th of December through the 29th of December. I'd like to see a proposed schedule for those particular witnesses. So that should give you some time for you to look at and consider which witnesses and contact them for their availability. Okay?
Yes, Your Honor.
That's fantastic. Thank you. Thank you very much.
All right.
You said
Also, if
18.
this-
No, go ahead. I was just trying to make sure I got the dates right.
All right. So what I'd like y'all to do is this will work between now and then, because I actually want to see a list and a schedule, just to make sure that we're good. And if I need to be available, or if I need to, I can make myself available. But it is my intent that week of the 18th of December to give our jurors some downtime to get prepared for the holidays. It is my intent to start back up on Tuesday, January the
I'll
2nd.
see if I can find him.
So we'll work about 3 weeks. And then we'll take that time, just do the scheduling and the holidays and everything else. But that should give you time to remedy that particular issue as it relates to any witnesses that otherwise have not been able to be resolved.
May I speak, Your Honor?
Yes, if Mr. Harvey and Mr. Matthews, if I can,
I was just checking on the dates, just to make sure, Judge, and I'm sorry, I was whispering too loudly, I guess.
all right, sir. Everybody, there's enough time for everybody. Yes, sir.
And then if the state would be good enough, they gave us a list for the next couple of weeks. But if there are people that you can tell us who's coming the first week, because this way, the 18th is after, obviously, the first 3 weeks, so this way we can review and court.
Okay, I get what you're saying. I can-
All right.
Thank you.
Okay, so I'm gonna expect to see like I said, a physical list on the first, and I was gonna tell you all on the first, it will be, I will.
Look how happy he is. Huh?
Yes. The physical list to the court on December the 1st.
Yeah, I want to see it so we can talk about it and you all can kind of just, that's just kind of a deadline so kind of as a forcing function, Ms. Love, so that I can.
Understood.
So you all have met before then and can give me a proposed schedule as to how many people you plan to talk to on any given day. And you can account for everybody so that, say, for example, you have 20 witnesses or whatever else, where you're going to do 3 a day or something like that, or you already talked to them and they're available these dates and these times via Zoom or in person. So it's to make sure that there's no issues about, well, I thought that somebody was going to be available. So I want to see some times and some confirmation that you talked to those particular people and they are going to make themselves available. Because one of the things is if they don't want to make themselves available, then I may need to go to another and make some other decisions, if appropriate. Okay. All right. And you're welcome to use me as the reason as to why they have to make themselves available. So, all right. Any questions about that?
No, Your Honor.
All right. It's conceivable also on the first that we'll just have, given some other things that the court has related to my other duties that we may have, our jurors may not come in that day, but we'll have that thing to do, and then we'll break for the day, and then pick back up on the 4th, that following Monday. Okay, all right. This point in time.
It is, Judge, or at least it's one of the last.
Okay.
All right, let's see. They want to
Judge, the state filed on October the 24th, 2022, state's motion and memorandum of law in support of the admission of gang-related evidence at trial. Additionally, Your Honor, we filed on.
Do you have a copy of that? Because I don't have my scribe. I don't have my assistant here today, Mr. Kearns. So.
Okay.
Thank you.
She wants
I've looked at it, but I just
criminal
don't have a
history.
physical copy and I need to.
No
look at
problem at
that.
all, Your Honor.
Fine.
For counsel's purposes, I am presenting to the court state's preliminary motion to introduce intrinsic evidence of criminal street gang activity filed November 30th, 2022. The state's motion and memorandum of law, can you all hear me? Yes. In support of the admission of gang-related evidence at trial filed October 24th, 2022. And the supplement to the state's preliminary motion to introduce intrinsic evidence of criminal street gang activity and notice of intent to introduce the same filed November 6th, 2023.
All right. All right, madam.
So, Your Honor, we filed on October the 24th of 2022, our motion and memorandum of law in support of the admission of gang-related evidence at trial. In our motion and brief, Your Honor, we specifically speak to the statutory authorization for the introduction of gang evidence, and those include the elements of proof in a gang act case, said elements including that the group falls within a certain definition. That definition being that a criminal street gang is any organization, association, or group of 3 or more persons associated in fact, whether formal or informal, which engages in criminal street gang activity as provided under Code Section 1615.3.2. And as such, proving the necessary elements of a criminal street gang requires that demonstrating that the group in question committed criminal gang activity. And the Gang Act then goes on to define criminal gang activity as comprising a catalog of offenses that are listed under 1615.3.
Yeah, but they weren't convicted as a gang. They were convicted as separate entities. So that's a hard stop for me. Just because you're alleging gang activity doesn't, in my opinion, doesn't mean you can bring in prior convictions into this as evidence. That's been the rule for a half a century in the United States. But you never know.
1A1. One of those defined offenses is racketeering activity, just for the court's awareness as it relates specifically to count 1 in this indictment. As it pertains to an individual defendant, 24-4-418 mandates for the presumptive admission of that defendant's other acts of gang activity for any relevant purpose, Your Honor. And 1615-9 explicitly mandates that gang-related evidence shall be admissible to establish the existence of a criminal street gang and criminal street gang activity. We have cited for the court the statutory authorization for the admission of that evidence. The third statutory provision that unequivocally authorizes the admission of gang-related evidence is OCGA 1615-3, which allows for certain specific types of evidence. And I am on page 6 of the motion that we filed at the top, Your Honor, in order to establish the existence of a criminal street gang. That provision of our code section states that the existence of the organization, association, or group of individuals associated, in fact, may be established by evidence of a common name or common identifying signs, symbols, tattoos, graffiti, or other attire or other distinguishing characteristics, including but not limited to common customs or behaviors. And pursuant to these statutes, the existence of criminal gang activity and criminal street gangs can be proven through a variety of means, including law enforcement officer testimony and statements of criminal street gang members and associates. Your Honor, as we outlined in section C of our motion, legislative intent dictates the admission of gang-related evidence. 24-4-418, 16-15-9, and 16-15-3-2 echo the specific and statutorily enumerated intent behind a gang act, namely that the gang act's purpose is to eradicate the crisis of criminal street gangs that represents a clear and present danger to the state of Georgia.
Yeah, I've said this before and I will say it again. The Georgia RICO Act is so vague and so broad. It more or less includes everything or anything as long as the prosecution brings it forward as an allegation. So it's a circular argument. They are a gang who commits crimes, therefore I can charge them with crimes as a gang before it's proven in court that they are a criminal gang.
The seriousness with which the General Assembly has determined the state of crisis caused by criminal street gangs present in Georgia is reflected in the compulsory increases in bail and mandatory conditions of pretrial release that are required in cases involving criminal street gang activity, as we outlined at the top of page 8. Further demonstrating the significance and gravity of offenses involving gang activity, OCGA 1761, section 13 requires that superior courts exclusively hear bond hearings on gang act cases, and consistently 1615-4L, as in Lima, imposes mandatory sentence conditions, and OCGA 17610, section 2 provides for extended periods of probation supervision for gang act violations. As the General Assembly has enacted specific statutes authorizing the admission of gang-related evidence, general objections with regard to that evidence, that is relevance, prejudice, character, when introduced for the enumerated purposes, Your Honor, must fail. And gang-related evidence should accordingly be admitted at the trial of this case pursuant to 24-4-418, 16-15-9, and 16-15-3-2. Your Honor, the basis for admission of gang-related evidence generally and without regard to whether or not there is a participation in criminal street gang activity charge is that although the Gang Act provides specific statutory authorization for the admission of gang evidence offered to prove the existence of criminal street gang and criminal gang activity, Georgia courts have consistently approved of the admission of gang-related evidence regardless of whether the Gang Act is charged or whether the victim of the offense was affiliated within a gang. Demonstrating the clear importance and viability of gang-related evidence, numerous appellate opinions describe gang-related evidence with no question regarding its admissibility ever mentioned. Of course, the admission of gang-related evidence pertaining to an underlying criminal offense and or defendant has been approved for a variety of purposes and in a host of contexts. Exemplary are the following areas: proving or explaining motive, connecting the defendants, explaining the defendant's presence at the scene, proving identity, clarifying the conduct of the defendants, providing context for the offenses, and or where part of the circumstances of the offense. Federal and other states' authority, Your Honor, is in accord with Georgia case law. Intrinsic evidence, which is also known as res gestae or background evidence, is evidence of wrongful conduct other than the conduct at issue introduced for the purpose of providing context in which the charged crime occurred. Intrinsic evidence is admissible without the limitations of or resort to Rule of Evidence 404B. And Your Honor, support for that is seen in United States versus Ford 784 F 3rd 1386 at Penn Site 1393, which is an 11th Circuit 2015 case. Intrinsic evidence, Your Honor, is admissible without the limitations of or resort to 404B rules of evidence. So in federal gang and conspiracy prosecutions, such as the state gang and conspiracy prosecution before Your Honor, a defendant's gang and conspiratorial activities have been classified as intrinsic evidence, including a defendant's gang membership. It has also included prior criminal acts committed as part of or reflecting the activities of the gang or conspiracy, and it has also included gang culture evidence. So here, Judge, the overwhelming breadth and weight of this authority demonstrates that whereas here, gang activity and or association is in some way connected with a defendant or an offense, appellate decisions have consistently authorized the admission of gang-related evidence. And where connections of this sort exist, gang-related evidence is admissible over objections that it might reflect negatively upon a defendant's character. And as such, Judge, gang-related evidence should be admitted at the trial of this case. Arising, Your Honor, in voluminous context, a broad spectrum of gang-related evidence has been ruled admissible in Georgia, and I'll give a non-exhaustive sampling, sometimes by category. Admission in a defendant's statement, belief systems, expectations of and ongoing gang members and associates, co-conspirator statements, colors, bandanas, hugs, and handshakes, incriminating statements made during offenses, internal policies and practices, items recovered during the search of a residence, items recovered during the search of a jail cell, numbers and codes, rivalries, symbols and signs worn on a person, membership or association, photographs showing hand signals and graffiti, tattoos, and witness bias. This is exemplary of the far-ranging grounds on which gang-related evidence is admissible under Georgia law. And accordingly, the gang-related evidence that we will present to this court should be admitted at the trial of this case. Your Honor, as we've outlined in section 5 of our motion on page 15, excluding gang-related evidence would violate the absurd result rule. So a fundamental rule of Georgia statutory construction, Your Honor, is to interpret legislative pronouncements in a fashion that will avoid an absurd result. The various provisions of a statute should be viewed in harmony and in a manner which will not produce an unreasonable or absurd result. That's from Rodriguez versus the state, 284 Georgia 803 at 805, finding Georgia's Gang Act constitutional. In this case, any argument against the admission of gang-related evidence would circumvent a...
Yeah, I think this is a hearing that was announced already in February, but they haven't gotten to it until now because there are so many motions and pre-trial motions in this trial.
An established case authority and contradict specific statutes, namely 24-418, 16-15-9, and 16-15-3-2, that expressly authorize the admission of gang-related evidence. Such an argument would also be at odds with the enumerated purposes of the Gang Act found at 16-15-2. This is all true because the 2006, 2010, and 2016 amendments to the Gang Act, one, specifically authorized the admission of gang-related evidence, and two, Your Honor, lower the burden of proving the existence of a criminal street gang relative to its pre-2006 incarnations. So opposing the admission of gang-related evidence in this case is tantamount to advancing the assertion that the General Assembly's actual intent in amending the Gang Act in 2006 and again in 2010 was to impede and prevent the admission of gang-related evidence rather than create more avenues for its admission in such a result.
Do I still have to consider 403 though?
Your Honor, as it relates to 403, where we are tendering, and I can give examples of the kind of acts that we are tendering, where we are tendering in this case, for instance, in...
Well, subject to 403, so you agree with me on that, right?
I believe that
intrinsic evidence is admissible subject to Rule 403.
Yes, Your Honor, I do believe that even intrinsic evidence is admissible subject to.
Okay, so assuming you lay the foundation and there's not some 403 issue that goes along with it, I think that's consistent with the current law and statutes. But what else?
So these particular other acts that we provided notice, and to be clear, there are acts again that we assert were committed by these defendants and acts that were committed by alleged opposition members of other street gangs, Your Honor.
And that's your supplemental motion filed on 11/6.
Yes, Your Honor.
And there's some almost 51 acts.
Yes, Your Honor.
Okay, and you've identified them and broken them out pursuant to individual persons, I see?
Yes, Your Honor.
Okay, all right.
I also believe, Your Honor, that, and I wanted to make certain, let me check it, that the acts that have occurred post the beginning of jury selection, post indictment and post the beginning of this jury selection, we are also intending to submit or tender evidence of those acts for the same purposes, Judge, as intrinsic evidence and as proof of count 1 in this indictment. As we've stated, each of the defendants is charged with participating in the RICO conspiracy of the Young Slime Life or YSL gang, a criminal enterprise, and therefore evidence of criminal activities committed by.
Say what? The name Mr. Jingles has the sound J and G. That nigga says he normally cannot pronounce. Well, J and G sounds similar in English for me. In Swedish, it is J och G. So I mix them up once in a while. But in this case, Mr. Jingles is pronounced with a hard G. So that makes it easier.
Individual defendants will be admissible as intrinsic evidence in any of the following scenarios: where the prior uncharged misconduct arose out of the same transaction or series of transactions as the charged offenses, and that is the activities of the YSL gang and the defendant's membership in or association with the gang. So for instance, Judge, where we have as an overt act 2 named defendants on the indictment, but we also have evidence that one of the participants in a particular act was not formally indicted. We seek to admit evidence that that defendant too was a part of this particular act. Where the prior uncharged misconduct is necessary to complete the story of the crime, and that the prior misconduct emanated from the defendant's membership in, association with, or participation in the YSL criminal street gang, or where the prior misconduct is inextricably intertwined with the evidence regarding the charged offenses, because of prior misconduct is part and parcel to the defendant's membership in YSL and YSL's criminal activities. So Judge, where here we have the Georgia Supreme Court stating in Roberts versus the state, 2022 Georgia Lexus at 15, citing U.S. versus Battle, 774 F. 3rd, 504 at 511 in 8th Circuit 2014 case. When evidence of other crimes tends logically to prove any element of the crime charged, it is admissible as an integral part of the immediate context of the crimes charged and is not extrinsic. So evidence of defendant's prior acts showing a connection to YSL completes the story of the charged crimes and can be used to show the existence of the conspiracy, which is an element of the crimes charged against each of the defendants before Your Honor today. So 404 limitations, 404B limitations don't apply. Where evidence is admitted as intrinsic evidence, rules about the admissibility of extrinsic evidence, such as those under 404B, do not apply. And for that proposition, Your Honor, we cite for the court's attention and consideration Harris v. State, 314 Georgia, 238 at 264, a 2022 case, where it states that Rule 404B is not applicable to intrinsic evidence. And Your Honor, none.
Well, Swedish, of course. Then it depends if you count Norwegian as a language or a dialect. German, English, of course. So that's 4. Then I can read a bunch of others. And I can understand a bunch of others. That's because I was a document analyst in the European Parliament for a number of years. So I kind of had to learn to at least read the language, because the European Parliament uses French and English as the official languages, but the separate countries often file their documents in their own language. So it all depends, but I speak Swedish, English, German, so 3. And then it depends around in the Nordic languages. I don't speak French. I can read French. That's a horrible language to read.
Of the restrictions of 404B substantively or procedurally apply to intrinsic evidence. Therefore, when evidence meets the criteria described above, it should be admissible against the defendants. Your Honor, as we state in part 2 of page 5 of our November 30th, 2022 preliminary motion to introduce intrinsic evidence of gang activity, intrinsic evidence, as the court has now stated and recognized, is admissible subject to Rule 403, and it is admissible if it satisfies it. Although intrinsic evidence may be prejudicial, Your Honor, Rule 403 requires exclusion only when unfair prejudice substantially outweighs prejudicial value. And the exclusion of evidence under Rule 403 is an extraordinary remedy which should only be used sparingly, Your Honor. And that is cited in Chambers versus the State, 351 Georgia Act 771, a 2019 Court of Appeals case. So any evidence the state will introduce as intrinsic, speaking to the court's concern, is subject to this extraordinary remedy under Rule 403. But generally, the state now moves to admit intrinsic evidence of prior criminal gang activity subject to Rule 403.
So many circular arguments in one motion.
Your Honor, and to name some of the acts that we have noticed defendant of our intent to introduce evidence of, and as well, Your Honor, I'd like to make certain that I point out that acts that were not alleged to have been committed by either of the defendants on trial before Your Honor are not all included in the intrinsic acts supplement that we filed on November the 6th. So for instance.
Okay, good for you. If you knew the language long ago, it shouldn't be that hard to get it going again if you started with it. Oh, for the rest of you, a million years ago, he spoke spoke and read French. Is it one? Yeah, something like that.
When
What do you need to do, a supplement at that point in time, so I could do the same, similar analysis is what I'm doing right now?
I think that would actually help, and so I can do that, and I will do that. Some of the, and I can do that and file that.
Well, I just think it's required, but just so that, you know, everyone else knows if you have additional statements, because I don't want to necessarily slow the proceedings down, to take up things that aren't necessarily, that we could have done prior to that. So file it, and then we can, if you have additional statements, I'd suggest that you file them, and then we can talk about them at that point in time.
Of course, Judge, and certainly we won't mention anything
Until such time.
Right.
Okay.
And so if the court desires that I go into the individual intrinsic acts and explain that, I can, or I can do however the court deems proper and respond after the court has had an opportunity to hear from someone else besides me. But we have listed them out in our November 6th filing. And these are the acts that we allege involve members of YSL. Just to name a few, there is the participation in criminal street gang activity conviction of Shannon Jackson and Kenneth Copeland, which shows the prior association between Shannon Jackson and Kenneth Copeland, and participation in criminal street gang activity involving the gang 30 Deep. We have noticed defendants of our intent to introduce an intimidation of witnesses in a criminal trial act the state alleges was committed by the defendant Williams during the trial of Quintavious Greer, wherein he had been charged with and was on trial for murder.
Your Honor, I sense that Ms. Love is going to read down the list.
I don't need the list to be read, so.
My observation, Your Honor, I've been through this list with some of my colleagues, is that each of these individuals quote-unquote alleged intrinsic acts or 418
I'm
acts that the
monetized. You
state
should be
alleges.
able to super
Each
chat,
of them are subject.
but let me check. So it hasn't disappeared. It hasn't. I'm monetized. Yeah, monetization on. You should be able to. Try to refresh and see if that helps. It might be your device, because sometimes iPhone can be a bit problematic. Everybody, try it. Everybody, try the super chats just to see if it works. Oh, but thank you so much. But if you can't, PayPal is the link to my PayPal is attached at the top of the chat, so you can do a donation via PayPal instead. And PayPal only takes a 5% cut, and while YouTube takes, what is it, 35, 40, something like that. Oh, maybe it is. Maybe it is. What time is it? What time is it? What time is it? What time is it? It is! Yes! It's grifting time. Become a member. $3 a month. And you will get access to the most members-only content among law tubers. I found out I produce more members-only content than anybody else. I wish I knew I would have produced this. No, just kidding. At least a couple of times a week, I put up something funny for you to watch as members only. And because the members is what keeps this channel afloat. And the occasional super chat, which gets me a better microphone, got me a bit of my new computer, and better lighting. And next project is to get a better camera. So that is what I do with your donations. Yeah, that's about it for my grifting time. Thank you so much. Grifting time over. And back.
403, and each of them individually have different levels of relevance and probative value, and different levels of dangers of prejudice and the like. There are some on the list that, I don't want to speak for everyone, but I've mentioned some people. There's some on the list that I don't think the defense necessarily objects to. There are other acts on the list that we object to vehemently, and the danger of prejudice is much greater. So I think, as opposed to Ms. Love just going down the list with the defense just remaining silent, perhaps we should be heard on each individual act and discuss the 403 balancing act of each. I just don't want to remain silent and for it to be perceived as if.
Well, I hadn't given you an opportunity to argue this one time, Mr. Shart, so I was going to do that. But the other suggestion is, I was going to say that depending upon when that particular issue is going, because it's subject to foundation. So, I mean, I think it might necessarily be better for me to, before this particular evidence is going to come out, that I make a ruling on it.
Okay.
I mean, because I don't have time at this point in time to go through each 41 act to do this, and it might just be better, depending upon the trial and pace of the case, for me to go ahead and take it up before it's and make that ruling.
And Judge,
When we get close.
what we can do to at least allay some of the concerns that counsel for defendants may have is to specifically identify any act that is on this list or that we allege is intrinsic and not charged prior to, when we give them witnesses, let them know, hey, this is going to include this act. For instance, I think that the first list of the first 3 weeks that we had intended to call does involve, for instance, act number 4.
Okay.
And
Any other act?
it includes as well act number 5. me see how far down we got. With the court permit me just a second.
Yes, ma'am.
Yeah, this prior act stuff is, but apparently it's been upheld on a federal level. That in a RICO surrounding, you can do prior acts, which for me is appalling. An already overly broad act that just diminishes due process and the rights of the defendants.
That was when we talked about things that happened. And when we come permanent, we said, oh, later on, so let's burn it down.
Yeah. And we are all very thankful for all you retail workers for the work you do this time of year. You are valuable. And don't do free work. Free work is wage theft. You are worth more. You're worth salary each hour you work.
So we also included in this, but not this. 14 as well, that date is. Number 14 as well, that date is 10/27/2014, but I have it mistyped as 2015.
Yeah, why? Yeah. This should have been handled long ago. Long ago.
And then, Your Honor, the acts that were committed by other people, for instance, the acts listed on our notice in number 13, which involved an aggravated assault and terroristic act upon the addresses listed on Maury Avenue. Those are the homes, that is the home or relative of a person that we allege is affiliated with.
They finished the jury selection last week. They started in January with trying to get a jury together. They finished jury selections last week.
YSL. So there's more than one of those type of acts. Essentially what we are seeking to show is the action and then its subsequent reaction by either the defendants on trial here or an opposition party. So the opposition party, of course, aren't charged in the indictment because neither of the defendants here committed them, but we will be seeking to show evidence of those. And I believe that if it was not Mr. Steele, my apologies to him for my misstating, so it may have been Mr. Sharp, forgive me if it wasn't him, but we spoke about whether or not there would be objections to information or evidence presented regarding what other people did, for instance, opposition shootings. And I think that someone had said that there may be objections to that evidence as well, so.
Other than 4, 5, 13, and 14, are those the?
They want in prior acts of other people than are charged. How is that even remotely possible? Hi, Shanagram. Tractor is outside. Kitty is about 3 feet from my feet and looking at them. So yeah, if you hear me scream, you know exactly what has happened.
Yeah, instances that you seek to admit the first 3 weeks?
One second, we're just going over to make sure. I'm 15, Your Honor.
Anything else? Because I'd like to take up those at this point in time right now so that you'll know whether or not they are admissible or subject to any other issues.
Okay.
And give the parties, whoever it is, an opportunity to argue about those.
Looking at the list, Your Honor, yes, I think that is.
Okay, all right. we won't take up those just a second. Do I have any other issues that I say at this point in time other than this 418?
We have a motion from Mr. Steele that the court may have already addressed that related to, and forgive me,
Thank you for your super chat, Will Call Magic, for your $5 super chat. You sent me an XDM. Okay, I will
or has
take a
a
look at it.
motion. It's filed on November 17th, and it's a motion to redact from the indictment any and all
Covered that
language.
this morning.
Oh,
We did,
that.
okay.
Yes.
And
You owe me an order on that.
so, okay, the one regarding the vehicle closely following Mr. Williams containing 4 individuals armed with numerous weapons and high-capacity magazines to include
Thank you,
AK-47
Christine.
and 30-round
Love you too,
magazines
Todd.
from the May 18, 2018 traffic stop as contained in count 1 over Act 75. Did we hear that one?
That's the one that you all, is that Williams 37 or 36?
No, actually, this does not have a number to it. It was filed, as I just read to the court, it has a longer title, and it's filed November 17th. I have a copy I can present to the court.
Is this pursuant to, let me see.
Okay, the word you are looking for is pronounced stavoran or stavoran, something like that. And thank you again for your super chat.
I think this may be part of what we covered this morning. We haven't addressed it specifically, but is there any other argument as to this, Mr. Steele, you want to make? And also, I'm going to ask you, so let me just kind of deal with that.
Sure. This is.
This deals with count 1 over to Act 75, and I did ask the Honorable Court to redact some of that language. You previously heard a motion to suppress. You denied my motion to suppress. If this jogs the court's memory, there were 2 vehicles. Mr.
Yes. Yes, sir.
So my position is the fact, and we heard the evidence, and you said, I'm going to deny your motion to suppress. However, there has to be some link to be tied up, some foundation that Mr. Williams knew that there was supposedly weapons in the other car. And, when I go through this, I don't see any evidence of that except the police officer's theory at the scene where they drive in tandem. And
I
so that's it.
I remember that.
Okay, and I raised it at the time, and that's why I moved to suppress, and you said you weren't going to suppress it, but you understood the issue and we would take it up later.
Yeah, okay. So is that, Ms. Love?
That is the motion that I'm speaking of. And of course, Your Honor, that from our perspective, that evidence goes to weight, not admissibility.
It would.
I'm sorry.
It would go to weight and not admissibility necessarily, meaning that you can present evidence on it. Of course, if you're able to substantiate that, that's fine. But, Mr. Steele's just, I guess, asserting that the only evidence you have is the testimony of that officer, but that's an issue for the jury to decide. So, Mr. Steele, I'm going to deny the motion to redact at this point in time. So you can include that, Ms. Love, in the order for the motion to redact the indictment. You can just put that we've considered this particular motion as well, and that.
Yeah, if you wonder, that was from yesterday. A police officer claimed he saw a Instagram movie of Mr. Williams holding or rolling a bud. So we gathered a few people, drove over there, and in those 2 cars, one of them was locked, the other one wasn't. And in one of the cars, they found drugs and guns. To my knowledge, none of them had been actually connected to Mr. Williams. And the car wasn't his. So I don't understand why it was allowed.
If you can either do a separate order, you can add that to that issue.
Yes, Your Honor.
Okay, on the 27th. All right. Okay, is there anything else I'm missing at this point in terms of any other additional motions, madam? Okay.
So, Your Honor, we also have, and this may have been included, I'll let the court instruct us, the motion to redact the indictment from showing any and all co-indictees who entered a guilty/Alford plea as distinguished from the motion to redact the indictment. So this particular motion was filed by Defendant Williams on November 3rd, 2023, wherein Mr. Williams moves the court to redact from the indictment any evidence that a co-indictee entered a guilty plea if the bill of indictment is to go out with the jury during deliberations. And
he couldn't say. He couldn't say when it was uploaded, if it was live or if anything. Just I saw it on Instagram. And when it got to, he claims he recognized the spot, drove there, and Mr. Williams was there, and that's it. And it was allowed in as evidence in this trial.
that's all that is asked. So I guess that this is something that could also be taken up at a later time. We are in opposition to the granting of this motion because our position, Your Honor, is that any admission of guilt by a co-indictee or co-conspirator would go to an element of proof as to at least count one, perhaps others in this indictment. And the fact that a guilty plea may be an Alford plea or something otherwise makes it no less a guilty plea or an admission. So we would ask that to the extent that this is different than the one we addressed.
Yeah, this, in my opinion, has been the prosecution's tactics all along. They indicted 28 people or charged 28 people, let them rot in jail until a bunch of them took a plea deal just to get out of there. A handful of them sat in jail for over a year without counsel because there weren't enough lawyers who were willing to take on the case. Posting a viewer's YouTube link. Well, I don't mind. You can post a link and you all can go over there and then you can decide if you want to prenumerera. What's the word? Yeah, if you want to join the channel and stuff like that. But you should. Christine has been with us for a very long time in the chat. More or less, I remember her from when I started streaming back in March. So she's been around for a long time.
This morning that the court denied this motion as well.
Mr. Steele, let's see.
So, Your Honor, just for ease, Sergio Kitchens, I'm just picking out his name. He pleads Alford for honorable court and receives a sentence. And if the state does not call him, or if the defense does not call him, my target is the fact that he pled Alford on the indictment that may go out with the jury is offensive to Mr. Williams and the other people because it bolsters wrongly the state's case. And it is not some admission that can be used against Mr. Williams because, and Your Honor,
He's talking about like the indictment itself it's got signature pages on it?
exactly.
I don't submit it's not usually my pattern practice, Mr. Steele, to submit those anyways. Once you all get a dummy, my pattern practice is to use a dummy indictment that both sides agree upon that goes to the jury. So they won't have any signatures on it.
Perfect. I mean, they'll have, I assume the people on trial is not guilty pleas.
Yeah, they'll have the stamp on it and everything else, but it won't have any signatures necessarily that from other folks.
Okay, that's great.
Your Honor, I'm sorry.
No, please.
I just wanted to point out that I don't disagree with the signature page not going out, but to the extent that a guilty plea, a certified copy of a conviction.
That's different.
Is tendered, right.
If that's tendered in the case in chief, then that certainly is separate. But in terms of just to that extent, whatever we come up with that is shown to the jury in terms of the indictment, who's ever left at that point, we can discuss that issue at that point. So, but no, I don't usually include a signature page.
Your Honor, if time permits and energy permits for everybody, would you take a peek? I don't have a physical copy, but at everybody, if you don't mind, it's State versus Jefferson, if this is a proper time on that issue. And it's 302 Georgia 435. That's 302 Georgia 435. It's a 2017 case.
An Alfred plea is, but for you who don't know, an Alfred plea is when you don't admit to the crime, but you agree that the evidence are overwhelming. Then you take an Alfred plea. As in, I didn't do it, but the evidence clearly says I did, but I didn't. And to get everything over with, the prosecution gives a plea deal. That sounds good, and you enter an Alfred plea. And I think the case is Alfred v. I don't remember, but that's an Alfred plea.
What? 302 Georgia 435. It's a gang case, criminal street gang case. It's written by former presiding justice.
Not a MAGA.
Chief Justice Melton.
Yeah. For you who don't know, there's been 2 years ago, Kyle Rittenhouse was acquitted. And there was a bit of a discussion over at Twitter about it. And since I went out with my opinion that it was clearly self-defense, everybody and their kitchen sink, all of a sudden, I'm a MAGA. They don't care that I'm Swedish, that I'm a union rep, that I do labor law, and probably save their jobs on a daily basis. No, just because I had that opinion, now I'm a MAGA.
And
So what happens is there's 4 people who go to trial or on trial together. They're charged with a conspiracy, including but not limited to murder or attempted murder, kidnapping, violation of violation of Georgia Street Gang Terrorism Prevention Act. So that's why there's other cases on this, but that's why I target it. And Your Honor, in
avoid the MAGA word
paragraph,
in the chat because YouTube traces every
on
kind of word
page-
in the chat.
it's an indented paragraph, I believe, Your Honor.
yeah, what are you asking me to consider?
Exactly what you just said about it's different about a certified copy of a conviction.
Yes.
It says, and I'm quoting, and it's I'm trying to get the jump site. It's in the paragraph beginning, contrary to the state's assertions. I don't see a page though.
Yeah, when it comes to questionable words, we use the word grape. We use words like self-ending. Use words we all know what it means, but it doesn't spell it out loud. That circumvents the YouTube censorship a bit more.
I think it's at Penn site 441,
Thank you.
section 2.
Thank you very much.
This is State v. Jefferson? Is that correct?
Yes, that's exactly right.
Hold on. Records.
Well, no.
I got you. Okay. All right. So it talks about they can't do business records.
Well, no. Well, yes, you are correct. But then it goes further. And if you find the indented paragraph that starts with testimonial evidence,
Yeah.
Okay. Encompasses not only prior testimony of the that the defendant was unable to cross-examine, but also judgments of conviction based on trials during which the defendant was unable to cross-examine when those convictions are used as proof of facts underlying the crime charged. Because third-party convictions, and that would be the convictions we're talking about now, Mr. Kitchens, Mr. Arnold, whomever, unless they testify.
Yeah, it's sequencing.
Okay, if they
I don't
testify,
have an issue. It's sequencing.
We have no objection.
If they don't testify, we're good. If they
Okay.
testify, then of course, then things are a little different.
and I thought what Ms. Love said, and I thought the court said, was that simply if state can stand up and say, by the way, 8 people have pled guilty in this case, and now
It's an issue of sequencing, and also it depends upon whether or not, who is the state's burden to prove, but those kind of things would be dependent upon much who testifies, if so, and they don't have to, so.
And if they testify, yes, obviously I have a confrontation right there.
Yes.
Okay, yes.
Okay.
That was it.
All right.
Thank you.
Yes, sir. So can the state prepare a suitable order for my signature on that particular issue as well?
Yes.
That was the, what's the title of the?
It is titled Motion to Redact the Indictment from Showing Any and All Co-Indictees Who Entered a Guilty/Alford Plea, filed November 3rd.
All right, so there's basically a couple of motions to redact the indictment.
Yes.
Okay, all right, so you can include that in there, madam. Okay. All right. Anything else that has not been addressed as of yet? Other than the 418, which we're going to. All right, while you're looking, Mr. Weinstein, any motions I have not dealt with pertaining to your client?
No, Your Honor.
Mr. Matthews, anything in regards to your client, sir?
1 second.
All right. Same crew to you, Mr. Harvey. Anything else I have not resolved in regards to your client?
I think there was a motion to eliminate recently filed based upon some recently provided screenshots. There's a motion to eliminate with regard to screenshots.
I think I covered those already.
I don't think so, not in my recollection. I could be wrong because they were fairly recently provided, so,
What, do you have that motion, sir?
no,
Do you have a copy of it?
no.
Okay, I'll find it. Could you, Christina? But just, you don't take a break. All right.
Your Honor, I'm about to pull it up. I can email it to the court and opposing counsel if it's easier.
That would be great. Okay. All right. Mr. Shard, anything I haven't ruled upon?
No, no.
Mr. Steele, anything else?
We do have outstanding motions, but you deferred.
Other than the ones I've deferred, sir, that specifically I've dealt with, do you have any other new ones that I failed to address already? Because I know you're going to remind me of the, there's about 2 or 3 or 4 that may come up depending upon what is presented. So you can just, before that time, just remind me that I need to do that. But do I have anything new or outstanding that I haven't ruled on, sir? Okay, all right, so I want to make sure. Mr. Williams, anything now? Yes, Mr. Matthews.
There is a motion to remedy that I did file. I'm locating it now. I filed it maybe a week or 2 ago. And once I pull that, I'll share it with the court. It's concerning redacting or excluding certain, in the event that the state decides that they want to introduce Mr. Healy's statement. There are certain aspects of the statement, there are certain information that he provided that I think are not relevant and possibly prejudicial. So motion limited in that regard. I'll pull that motion. I'll re-forward it to Mr. Kearns.
Just re-forward it to me. You can forward it to Mr. Kearns as well, but forward it to me as well as the state so I can look at it right now. If you wouldn't mind, sir. All right. Is there anybody else? Or any other things, Mr. Matthews?
No, Your Honor.
Okay, all right. Anybody have not otherwise addressed as of yet? Okay, so Ms. I hope you're forwarding that?
Yes, you should.
Okay, anything else in regards to the state?
I did have one thing, I apologize.
Yeah.
You ordered us, I asked for it up and you said, yes, do that.
What, I'm sorry about what?
I'm sharing I have a PowerPoint.
Yes.
Share it, so I thought you want to, for everybody.
Did we deal with that issue already? Or have you all?
You said to share it before opening.
Yes, I did.
Any issues you might have resolved before we switch.
Well, yeah, that would be a Monday morning thing but I would hope that you all share with each other before Monday morning so that I don't want to take up too much before this jury comes out because I'd like to really kind of go and get started. So if you all, to that extent, are you in the process right now of sharing your openings in terms of whatever the PowerPoint says? I know you all said you were going to do that. So.
I should have it done sooner than today.
All right.
For tomorrow, I believe I'm going to send it over to everybody.
Okay.
And we will do the same once we.
Just to be clear, we're talking about demonstratives,
Anything that you're going to use in opening. So there's no surprises. And speaking of that, I can either, in terms of, for those of you that wish to make opening statements, I'll give you the opportunity to do so. It's built into what I tell the jurors. So you can be prepared at that point in time to make your openings in whatever order you want to, or I can pick one. We'll just do numbers out of a hat.
Your Honor, can we do that for cross-examination as well? Like if Mr. Sharp really about his time, but I want to cross-examine you. Can he go first if he wants to, and then I'll second the next witness?
Sure, I don't have any issue with that. I'll pick unless there's, disagreement to the contrary or non-concurrence. So I'll do that in the absence of agreement. Okay?
Your Honor, as it relates to opening, I don't.
Answer my first question. You have any other motions?
I moved the court for all day to do up. No, I'm.
Okay, all right. Because I'm trying to get things done so you all can have a relatively, as much as we can, smooth Monday for our jurors. Okay, so I'm trying to rule on everything that's outstanding, so I don't owe anything to anybody, or if somebody doesn't say, "Well, Judge, you didn't rule upon this," and I want to make sure because in my opening statement, I don't want to have that. So I'm trying to make sure that we've covered everything that potentially might be an issue that I otherwise have not deferred ruling on yet for reasons thereof. Okay. What's your question as to opening, Ms. Love?
Your Honor, is the court, are the parties constrained time-wise with openings? Could the court give us just any direction that you have in mind at this moment, not trying to tie?
Brevity is good, Ms. Young. Ms. Love. Brevity would be good.
I don't know.
I've done this a lot. I mean, look, I will afford you a reasonable amount of time, but I'm not going to cap you. I just hope you're not going to go 3 hours or 2 hours, but that you I remind everybody about the concept of primacy and recency. So, but to that extent, you all need to make whatever opening statements you need. Yeah, you think they're within your entity's best interest.
Oh, and Your Honor, we did have one more matter that a colleague wrote.
What was the other matter, madam?
Was, Your Honor, we can address it whenever the court deems fit, but the court indicated after ruling with respect to one of our motions as it related to statements that were made and captured on a body-worn camera that the court might be inclined to consider a motion for reconsideration. We did file one.
No motion for reconsideration of the body camera. I didn't say that.
Okay.
No.
That was wishful thinking. And
no.
Yeah.
Done. Don't bring that up again.
Understood.
All right. Okay.
Got it.
All right.
No problem.
What else? Do I have any other administrative inquiry about Monday? I'm going to go through, after I welcome our jurors, I'm going to go through the standard covering them, what they can expect. I'm going to probably reiterate the issues involving the ad nauseam admonitions. And then let you all get started.
What time will we begin on?
9 o'clock.
Your Honor,
Sir.
do you know what time you can enter the court room or courthouse?
I don't know if Mr. Kearns got to that letter or not, but we'll just deal with it the best way we can. I'm going to try and get, I don't know if I signed it, and I don't know, because he was working on it before he left to get,
Hi, Megan.
so I may have to complete that Monday, Mr. Steele. So just remind me, but I was going to do an order to get all of you. Did you all provide that to Mr. Kearns? I think he was working on it.
Excuse me, Judge, I believe that order went out a day or two ago.
All right, so I think it's at the desk already. So you should be able to get in early, Mr. Steele, before 8 o'clock or thereabouts. Okay? All right.
Okay, turning up to 1.5
Okay,
speed, so we get through this.
I'll do with this motion to exclude the screenshots and the motion limiting as it pertains to Mr. Harvey's raised and Mr. Matthews. But let me go ahead and take up the 418 issue. So let's start out with number 4. It's at 5/12/2013 matter.
Your Honor, the act listed as number 4 in the intrinsic acts filed by the state involves a home invasion that was committed by, we allege was committed by Mr. Williams and Mr. Murphy. The victim in that case, I don't want to broadcast the name, but we have provided the defendants notice of and discovery for that particular incident. There was a police report that was filed, and just for reference sake, it is APD case number 131331506, where that named victim reported to the police that defendant Jeffrey Williams and co-conspirator Walter Murphy, along with another party, committed a home invasion and that they burst through her door, held her at gunpoint, and stole items belonging to her, including but not limited to.
This is almost a decade-old case where they never brought charges to Mr. Williams. And here we are, almost a decade later, when they want the witness. I mean, as I said earlier, this RICO trial is about trying to convict them by sheer volume around cases they couldn't even bring charges towards the defendants a decade ago. But here we are.
A firearm, as well as money.
What's KVLT? Oh, I listen to the genre, but I don't consider myself that much into that genre. And the genre of metal we are talking about is called black metal. And I listened to a few of those bands. I've listened to a few of those bands live. It's extremely aggressive music and with very interesting lyrics. But if I'm at the few occasions I need to get rid of aggression, that kind of music is blasted in my ears. Because after an hour of those, I'm calm.
The defendants are alleged to have then left the residence and fired a shot into, I believe, the doorframe of her residence before leaving. The victim in that case went to the police station and reported the home invasion after being urged to do so by her mother. The police spoke with a juvenile witness on scene who was a neighbor. And later, the police reported that the defendants returned to the property and apologized for committing the home invasion. Your Honor, the state's position is that the act of the home invasion with the co-conspirator, Walter Murphy, committed by Jeffrey Williams, is an overt act that tends to show and to prove defendant Williams' understanding and willingness to participate in racketeering activity and to conduct YSL through a pattern of racketeering activity is an overt act that the state will tender evidence of. We will not and do not intend to make any mention of that act unless and until the state has presented evidence and the court has admitted that evidence.
All right.
It shows, again, the types of crimes that the group commits. It shows the earlier relationship between the defendant and an alleged co-conspirator, Walter Murphy, who now has entered a guilty plea. And the victim in that case is tied to a gang that is an opposition gang. If the court wishes that we just address them one and then
Let's do that, yeah. I would like to. Thank you, Ms. Lowe. All right, Mr. Steele?
Thank you, Your Honor. This is allegedly May 12, 2013. It's Mother's Day. The alleged victim, just for purposes of this motion, is A as in Elisa, or Alpha, B as in Barry or Bravo.
One is sufficient, so I prefer you use Alpha or Bravo, okay? The list is on the podium, too, so if you cramp up, you can just use that, okay?
I'm trying to
We're
look.
gonna try, you'll get there.
This is the facts in the report are a little different than the way I understand it, than what the state said. So what I understand is it's not a home invasion. It's Miss A.B. Reports to the police that Mr. Williams is friendly with her boyfriend. They were allegedly together the night before. She said because of that, she didn't think anything of it, opened the door. She states that Mr. Williams and Mr. Murphy and Mr. Williams' brother, she does not say who it is, comes into the home. And supposedly, when she turned around, there was a cell phone and some money taken. And Mr. Murphy supposedly fired into the wall in the house. She did not report anything to the police. The next day, she made this report that I just told you. The night, so that happened during the day, allegedly the night, supposedly bullets were then entered into her home. Nobody says it was Mr. Williams or Mr. Murphy or anybody else. There's no evidence of who shot later into the house. She did make that report to police, never made an arrest. The police report finds that AB was untruthful. Mr. Williams was never arrested nor charged. The state first noticed me of this.
Is AB gonna testify?
We can listen to her.
Okay.
So I have tried to find AB for months. I found AB when the state first gave me her information, and she supposedly lives there, but I can't get her. And that was on September 26, 2023. That's one of the people I need to interview. I never interviewed.
Is she gonna be, I was gonna ask you that, is that somebody that you're gonna seek to interview and also run a criminal history in?
Absolutely.
Okay, all right. Well, let's assume that she's available. Would that change your, I mean, I'm sure you probably disagree still, but would that change the analysis or argument?
Well, I have factual analysis and I have legal analysis. The state's notice, and they did file in, I believe it was October 2022, a preliminary motion to admit.
They did.
Gang evidence, but it's like a boilerplate. There's no specifics. The specifics come on November 6, 2023. And I'm including, this is just how I look at life, I'm including September 26, 2023, because on that witness list we got, that was the good witness list when you made it known that this is unacceptable. And on that witness list, it does say 418. So I took that as notice for September, this past September. But notice according to statute has to be 10 days before trial. We've been through that a lot, but that's in the statute itself. And this is not 10 days before trial. And, Your Honor, because Mr. Williams was never arrested nor charged with this, there is a great presumption not to admit it because, let me go to the case. Because the prejudice is great and the danger to admit this type of act where the accused was not previously charged or convicted is too great. And that's Rivera, R-I-V-E-R-A versus State. Your Honor, it just came out, so I have a site, the case site. It's S.
Is that what's the last name or?
I have a, hold on, I'm just gonna pull it. It's, if you have it, it's S23A 0429, if you can.
You want Alexis to do it?
The county only allows me to have Westlaw, so.
Hi, Sal.
What's the?
S23A
S23A.
0429. It's Division 3.
Yeah, I mean, as I said, never arrested, never charged, never convicted. This isn't even a prior act. This is a prior allegation that never was charged with. and the state wants it in this trial. Hi, MG Law. Oh, you're going to be pissed off about this. The prosecution wants the court to admit a police report about an alleged home invasion. And the defense attorney just read from the police report that what she said, the prosecution, is not in the police report. Nobody was charged, arrested, or convicted. This was in 2014. And she wants it in under the RICO Act. She wants that admitted. Yeah, I mean, but Georgia RICO Act is... Yeah, the police also said that the complainant was not honest with the police. So, and they still want it in.
Rivera. Look at that.
Yeah. RICO...
Yeah, I do have a Westlaw. I was able to get a Westlaw site, Mr. So yeah, thank you.
Yeah. The Federal RICO Act, I think, has been challenged and has been approved. The Georgia RICO Act has never been challenged outside of Georgia.
I see we got right here. All right, so
that's one reason. So I have that the facts, I'm not saying Ms. Love did that intentionally. The facts I'm just saying from the reports, that's all I have. The facts are not the home invasion, the shooting that night. 1, 2, the notice is just late. I mean, that's just fatal to me. There was no reason for it. 3, Rivera does say the language, and it's 403 analysis. It's in the paragraph, the last paragraph before Division 3. We recognize that the admission of this other act evidence carried a risk of prejudice to Rivera, particularly since the state did not demonstrate that he was charged with any crimes arising from the Irwin County instance, and because the state chose to emphasize the Irwin County instance again during closing argument. And there's many cases on that it's in here. It says, under Hood versus State, noting the danger of admitting extrinsic offense evidence is greater where the extrinsic activity was not the subject of a prior conviction, because the jury may feel that the defendant should be punished for that activity, even if he's not guilty of the offense charged. So, that's my other reason. My fourth reason is the state said that they need this evidence for specific reasons, and I challenge those reasons because I'm not challenging anything. They said there was a relationship with Mr. Walter Murphy. Your Honor, I will never say that there's not. These two gentlemen grew up together. Mr. Walter Murphy has been on tour with Mr. Williams. There are photographs of them that the state served in discovery together. So the fact that they want to prove a relationship is not needed. When Ms. Love said, Your Honor, it's also important to admit this because Ms. A.B. is part of an opposition.
The state's position in this is that it shows gang relations because one of the persons they alleged was in this home invasion has done a plea deal in this RICO case. I mean, it's... Yeah. So because he was with a person who now pled guilty to some odd charge, they want to use a prior act they were never charged with as evidence for gang affiliation.
Gang, she said that was the last reason. Look at the date. This is 2013. That opposition gang doesn't start until January 6th of 2015. That's
Isn't that a weight issue? I mean, if it's admissible, doesn't the jury have to decide that?
No.
Decide that issue?
Never, because if it's an opposition gang, but they're not opposed at that time, that Mr. Williams was friends.
But it shows that okay,
she let him in the house. That's my point. This does not go to the RICO count, and to show that there was some hostility. And this is not 418 evidence. If you heard what Ms. Love said, this is not 418. She's trying to say this is for the RICO count. RICO is not 418.
Well, Rivera talks about 413. And actually 413, but do you have anything in that respect about the 418? Or am I missing something in Rivera?
Well, I can give you other cases if you want. You mean for the proposition that a person's not arrested and it could be unduly prejudiced?
What division is that in?
Division 3 in Rivera.
Division 3?
In Rivera, yeah. It's the last full paragraph.
I got it. I see it. Okay. All right.
And the court found that, yeah, it might have been error, but there's substantial evidence against the person, so let's not do it. And that's the final thing that's going to be throughout all this, Your Honor.
Okay.
I know you're going to be fielding a lot of objections on admission of information and evidence, but the bottom line is this. I probably can't get around. There's 191 overtax already in count one. How much more does the state need? And that's under Thomas, THOMAS. I'll give you that site. It's the prosecutorial need under 403. There's nothing. There's no prosecutorial need here. What Ms. Love said, the three reasons that she wants to admit it is understanding and willingness to participate in RICO activity.
Types of crimes and the relationship with co-conspirator.
Relationship with Mr. Murphy, the opposition gang, which at that time it is not. There's no opposition gang. Actually, I'm proffering to court. I promise you, this accurate. Those two alleged gangs were friends. You heard that from some of the experts who testified. So that's not a reason to admit this. That'd be like saying, Bruce Harvey and I got into a fight today, and then 5 years from now, Bruce Harvey doesn't like me. We're friends today. I mean, it doesn't show anything. And then it's really propensity. We're not in 418 where propensity is okay. We're in RICO. This cannot come in 418. And
I'll tell you what. I think you all need to probably talk to the witness because you all profit a lot. And you haven't, has the state interviewed the witness at all? Yes, no? Have you interviewed AB?
Oh, Your Honor, we have.
Come on, answer my question.
Whatever it is.
That's a no. All right. I think you need to interview her before I conclude on.
They haven't interviewed her, and the judge says, let's rule on it later. Fucking hell. How is this even near being allowed in? I don't get it.
This, because that may resolve part of your issue.
Okay.
And then I'll just defer ruling on it.
all right, I
Okay?
understand.
I mean, let's just make sure that you've been able to kind of substantiate what you think she's going to tell you before I rule.
Okay, and then just for I'll back down, but just for all these that we're about to go through, I'm going to have a final argument. Everyone, if there's 191 overt acts, I mean, how much more? And you let in, respectfully, over my jack, you let in 19 lyrics. I mean, at some point, we got to go. I mean, this is just extending. Anyway,
I understand.
I know. Okay, thank you.
All right, let's cover number 5, and that's the incident on September 11, 2013.
Yes, Judge. And with court's indulgence,
September
I
11th,
briefly just wanted to
2013.
touch on the fact that the state is not intending to proffer to this court that we are offering, as if it were a 404B proffer, these acts for specific exhaustive purposes. Your Honor, the act itself that we are tendering, specifically the one just addressed by Mr. Steele, also would go to prove the existence of an enterprise, the existence of an understanding and willingness to participate in and conduct this enterprise through a pattern of racketeering activity. In no way did I intend that the court accept the recitation of events that I presented and reasons that I presented as an exhaustive reason for admission or exclusion. So I wanted to make certain that that was.
But you're introducing it for intrinsic purposes. And
right.
So why are we, okay.
And so
I'll defer ruling on it until you need to interview the witness first and then determine what you know. Because you don't know. I mean, unless you talk to this person, which you haven't yet, you can't proffer any of this stuff to me at this point. I mean, you can, but you all made an argument, but I can't rule on it.
Okay.
So let's circle back to that at a point in time. I'll just defer on at this point in time. So let's move on to the September 11, 2013 attempted armed robbery, fleeing, attempting to elude at 13 SC 122087, Walter Murphy, Mr. Williams, and Adrian Bean.
yes, Your Honor, just one moment if the court will allow me.
I don't get how this is even up for consideration for future rulings. It was
Your Honor, this
before.
particular event or act is one of the overt acts that is listed on the indictment itself. Specifically, it is listed in the indictment as act number 4 through 7. But in the indictment, Your Honor, only Mr. Murphy is listed. What we have, Your Honor, is evidence of, and this was provided to the defense in July of 2022 in the report that we referenced in the prior act that we seek to notice or introduce evidence of was presented in 2022 as well. So this particular act involves a co-conspirator who is alleged to have committed this particular crime with the defendant, Jeffrey Williams. Specifically, in this case, Derek Dotson is someone who was targeted by members of YSL for an armed robbery. Mr. Dotson had a substantial amount of money on his person. Mr. Dotson is also deceased, so he won't be testifying, but there is a plethora of information about the incident that is available and legally admissible that the state will be presenting. Mr. Dotson was robbed at gunpoint. I'll just state in my place that the information we provided to the defendant shows that Mr. Dotson, when speaking with police, was yelling, "Thug is the only one out of that group that knew me. Thug had this happen to me. Thug made this happen." So as we listen to the jail calls of the people who were caught, Mr. Dotson's robbed at gunpoint. Mr. Murphy holds him at gunpoint. While Mr. Murphy is attempting to rob Mr. Dotson, he is in the car previously to this, prior to the robbery, he's in the car with an Adrian Bean and the defendant Williams. And when Mr. Murphy gets out of the car to rob Mr. Dotson, a law enforcement officer, Roberson L., is nearby and hears the commotion, responds. When the law enforcement officer responds, Mr. Murphy begins firing shots at the law enforcement officer. As that happens, Mr. Bean jumps out of the car, goes right. Mr. Williams jumps out of the car and goes left. And during a subsequent jail call between one of the witnesses and his wife, the witness says, "I should have followed my mind. Thug went left. I should have followed him, and instead I went right." Police then go and take that witness out of jail and interview that witness, who will be here in person to talk about it. And he then tells the police how Jeffrey Williams orchestrated that particular armed robbery.
Have you interviewed the witness yet?
Yeah, we have talked to that witness.
Okay, all right.
So, Your Honor, that is significant because later on during the Jimmy Winfrey shooting, which happens in 2015, in the latter part of 2015, Walter Murphy is one of the members of YSL who is on scene at the compound at the Lil Wayne concert before the bus shooting occurs. While they're at the compound, the court has heard some testimony from Investigator Dennis about what took place. But after that, Your Honor, Mr. Murphy and others were interviewed. And one of the things that Mr. Murphy said that is telling is that he had done enough for Thug. All that he is required to do now is watch his sisters. So, Your Honor, this particular act, this armed robbery, again shows Mr. Williams' tacit, if not explicitly stated ever, agreement to participate in and conduct YSL through a pattern of racketeering activity. It shows the actions of the participants in YSL, the criminal actions, the type of crimes that they're committed, and in no way am I intending to offer an exhaustive list of why it's admissible. It's admissible because it's intrinsic, it's the state's position. And contrary to any representation.
It's admissible because it's the state's position. What?
Otherwise, it's not that, this evidence is prejudicial, as I think was referred to by Mr. Steele in Rivera, the prejudice that exists in relation to particular evidence when there has been no arrest. But the risk of prejudice has to rise to the point of being unfair prejudice, which substantially outweighs the probative value of the evidence offered. And there's not an analysis under 403 relating to the need for it as there is under 404B. This is, again, intrinsic evidence of the existence of and conduct of the enterprise.
If it's not been handled by a court, it's not evidence, it's allegations. If they haven't gone through the court system, gone to a jury or judge, and then a conviction, it's not evidence, it's allegations. How is this even near allowed?
YSL itself in earlier stages. So we would ask that the court not exclude this relevant, pertinent evidence from the jury's consideration. And I will reserve any further comment or argument as time as the court permits me to respond to Mr. Steele's.
Okay, Mr. Steele?
It's now an infamous day in America or the world. It's 9/11/2013. Mr. Dotson is supposedly, it's not an armed robbery, it's an attempted armed robbery. There are 3 people there. There's a car that is borrowed from another person. It's being driven by a gentleman named Mr. Bean, B-E-A-N. There's a Mr. Plethro, P-L-E-T-H-R-O, supposedly in the car, and Mr. Murphy, who's a co-indictee. There's zero evidence that Mr. Bean and or Mr. Plethro are involved in any criminal street gang activity, including YSL. Mr. Dotson is unfortunately from other unrelated reasons, no longer with us. The state has never given me any type of notice as required by law to introduce any type of statement from Mr. Dotson. The statement was not anything of Thug did this. What he said was, which I don't know how lawfully anyone can get it into evidence under a rubric of a statute, but what the gentleman said to law enforcement, so his confrontation clause matters, is, I saw Thug earlier today. He knew I had money. That's what he said. He never sees Jeffrey Williams. He doesn't put Jeffrey Williams there. Mr. Plethro is interviewed, shot. So when the shots go off, law enforcement is already in the area. They're there immediately. Mr. Bean is driving this vehicle. He almost strikes the police car and the police officers. There's a chase. Police officers are firing at the car. The car goes off a careen, like an embankment. It goes over a police car and slams into a side of a laundromat. And Mr. Bean is captured. He's running. Mr. Murphy shot, taken to the hospital. And Mr. Plethro shot, taken to the hospital. Mr. Plethro is recorded in the hospital. He names people who are there. He names Mr. Bean and Mr. Murphy. He does not name Mr. Williams. Mr. Murphy is interviewed at the hospital. He doesn't name anybody, but he says that there are, he does not name anyone at that time. Years later, Mr. Bean, excuse me, if I say Mr. Bean, I'm talking about Mr. Murphy. Mr. Murphy is giving a proffer in this courthouse. Actually, the Honorable Suri Chada Jimenez is the prosecutor in that video. And Mr. Murphy is represented by the Honorable Jacoby Hudson. And in that proffer, the state is constantly asked about Mr. Williams, and this proffer is in the summer of 2015, years later. Mr. Murphy never says that Mr. Williams is involved in this armed robbery. He never said. What he says was, "I've done all this work for Thug." He carried bags for Jeffrey Williams while on tour. These two people grew up together. He said nothing about.
Is Mr. Murphy testifying at trial? Yes.
Well, I've interviewed him about this, and he stays with his prior statements. So maybe the state has different interviews with him, but that's what he told me. He's not involved. Mr. Williams is not involved.
Oh, really? Defense has interviewed him, and this guy is standing by his prior statements. That Mr. Young Thug, Jeffrey Williams, he never names him. And the state still wants it in against Mr. Williams.
In addition to that, Mr. Williams is never charged. He's never arrested. It is an overt act. It's in 4 through 7. I don't know if you saw the indictment, but if you look at it, Mr. Williams is not named in overt act 4, 5, 6, or 7. I don't have my indictment in front of me. I don't have the page number. I'm coming.
Okay, I believe that Mr. Williams is actually named in 4, overt act 4.
He should, if you look at it, I'm not looking at the indictment, but this is September 11th, 2013. He should not be in any of the.
This is I'm sorry, this is the, says on or about, if I'm looking at the right one, part 3, action furtherance of the conspiracy, I flipped too far, let's see. Is 9/9/2013.
That's the different, that's what you admitted the other day.
Okay, that's different. Okay, all right. So let me see if there's any. Oh, okay. It's Act 5. It is. You're correct, Mr. Steele. 9/11/2013. Okay, we have over Act 5 is Walter Murphy. 6 is Walter Murphy. 7 is Walter Murphy. Yes.
So I'm not charged with. They're not. I got no notice of Mr. Dotson, which DOTSON, by the way. Any type of statement. So I don't know how that comes in, and it was to the police. It was confrontation clause, and it's prejudicial and.
Okay, Mr. Johnson is deceased.
Yes, he is. He's no longer with us. That was an unrelated. This is a decade ago. So
I'm sorry. What was the last thing you said? I apologize.
This is a decade ago. It's on September 11th. He passed years later. So the state doesn't need it, and I hear their reasons, but their reasons are not being litigated. I'm not opposing that Mr. Williams knows Mr. Murphy, and Mr. Williams is involved in overt acts, numerous overt acts in this case. I mean, why litigate something that was never litigated then? And then you have to go back to the Rivera case, which teaches us that the jury could, I'm not saying they will, but they could look and say, well, he wasn't punished for that. And I believe it. So even though he's not charged here, I'm going to convict him. And that's exactly what is going on here. And it's for propensity. And we're in a RICO. We're not in a gang. I understand certain crimes against children, God forbid, or sexual crimes can come in for any purpose and gang act evidence. But this is not gang act. This is count 1.
but this is a prior conviction. Rivera seems to indicate that it says, noting the danger, it references Hood, 299 Georgia 95 105. The danger of admitting extrinsic evidence is greater where the intrinsic evidence was not the subject of a prior conviction, because the jury may feel the defendant should be punished for that activity, even though he's not guilty of the offense charged.
Right. That's what I have. Mr. Williams was never arrested, indicted.
We're trying to use the 13 SC 12207 incident.
No,
That's what's referenced in their 5.
Yeah, but Mr. Williams is not charged. It's what you just read is on point to Mr. Williams. That's the whole point of bringing in other act evidence that was never charged. It can really get jurors to say, I'm going to get him for this one. That's a 403 analysis. And 403 talks about prosecutorial need, and they don't need any. They have 191 overt acts. And I insist, Your Honor, I've made it known throughout. I'm challenging the admission and the applicability to Mr. Williams of all the 191 acts, but the state has always pushed back and said, no, we're going forward with every 191 overt acts because we want to show that the act of one is the act of all. If that's true, why would the state need anything further? It's already enough. I mean, I have 190.
Okay, well, here's the thing. Would it make a difference if Walter Murphy testifies that, Thug and I ran together and the state asked them applicable questions about membership or whatever? Wouldn't it depend upon whether or not what Mr. Murphy testifies to?
No, because
as to whether or not this overt act is. I mean, here's the thing. Even though Mr. Williams wasn't charged, is Mr. Murphy going to identify Mr. Williams in this particular 9/11/2013 act?
No, and I haven't heard the state say the opposite.
Madam, yes.
Your Honor, so there are a couple of things. We expect or we believe that Mr. Steele's argument that he's making to the court right now goes to the weight of this evidence and not its admissibility, particularly because he keeps pointing back to Rivera, which deals with extrinsic evidence of an act having nothing to do with the act the defendant is charged with at the time of that trial. Here, Your Honor,
It's intrinsic.
It's intrinsic, and not only is it intrinsic, but it's one of the ones that Mr. Williams has had notice of and discovery on since day one, the entirety of that file. So that's not only what I just said, Your Honor, but Mr. Williams' part in that attempted armed robbery and that aggravated assault, it completes the story. And it also proves other aspects of crimes alleged in this case.
There's basically no evidence he was ever there. Yeah, I agree, Michael. It sounds like the judge is trying to find a way to allow it in.
The state has the burden. The state alone has the burden of proving.
If Mr. Murphy is going to testify about what Mr. Williams did, I'm going to allow it.
And not just Mr. Murphy, but there was Mr. Bean.
Yeah, if there's going to be testimony about acts committed allegedly, and I'm sure that you'll examine them as to it, then that overt act, I'll allow the state to probably present that, even with the court doing a 403 analysis. That would be relevant to show participation, among other things. But assuming that, and that's assuming, Mr. Steele, that there is going to be direct testimony from people, Mr. Bean or Mr. Murphy, about the alleged incident on 9/11/2013. I'll admit it over a year. I mean, subject to foundation and other objections, I'll at least allow the state to attempt to present that.
Your Honor, since it's one of the overt acts that we offering evidence of anyway,
Yeah.
and we would never, I mean, if we don't have a proper foundation, if we don't have competent evidence by which to admit a particular allegation or act against a defendant, we're not going to proffer it in front of the jury and then
Well, I hope not.
our face. That would be.
I would hope not,
contrary to
but
everything.
Mr. Steele's got a job to do, and you do as well, and I don't have any issue with that. So, Mr. Steele, I'll over your objection at this point in time, subject to a foundation and further objections, okay?
Yes, sir. Can I have it for purposes of this ruling? Can I have a continuing objection? And
You may, but I would suggest that you make another timely objection before it, depending on what is presented.
I will do so.
Okay?
Yeah, of course.
All right. Let's move on to,
The risk here is the prosecution calls one of these up to the stand and asks a bunch of questions, and all. Then they can argue, well, they don't answer because they are in a gang, or something like.
13, that is the 2/16/2015 aggravated assault terroristic act shooting at 114 and 156 Monterey, Mike Oscar Uniform Romeo Yankee Avenue, Atlanta, Georgia, shooting with a rival gang, APD file or report number 150503213.
Your Honor, do we have 5 minutes? 2 minutes? A minute or
Dang. Yes, it's a negative offer. Yes, you can have 5 minutes. Yes, sir. And the rest of you as well, so.
And fast forward. Yeah, I'm amazed about this. Is the Georgia RICO Act. It allows so much shit in that shouldn't be allowed in. It's infuriating.
All right, Ms. Love, go ahead and if you want to present number 13 that we've already identified for purpose of record.
Yes, Your Honor. So the evidence that the state intends to present as it relates to the listed Act 13 on our November 6th notice has more to do with the fact that the shootings occurred. These are acts that the state alleges were retaliatory acts that were committed by members of a rival gang. So they are not acts that the state is attempting to show either of the defendants currently on trial committed. So our position with respect to that evidence and similar evidence where we're not alleging either of these defendants committed the act is that, and I don't know that it can be said to prejudice or to substantially or unfairly prejudice the defendant in such a way that substantially outweighs its probative value. The retaliatory shootings committed by people other than YSL provide context or other acts that state alleges that members of YSL committed. So
They want in that other people shot at them, and therefore it's retaliatory, and therefore they are a gang.
we would ask that the court not exclude any acts, and we didn't list every act that we intended to show evidence of that we don't know that was committed by one of the defendants, and we will not, of course, we know that any presentation of the evidence is subject to the court's determination of whether or not the evidence is in some way unnecessary or cumulative or any other reason that the court may be proper for the state not to present it. But it's our position as it relates to this particular one and ones like this that neither of the defendants really have any reason or cannot really assert any prejudice through the admission of this evidence. So if the court permits, I'd like to just speak on it once anyone else has had a chance to respond.
All right, let's see if anybody else is. Mr. Steele or Ms. Sharp?
Your Honor, I think I speak for all of us. We don't have any opposition to, now I'm not agreeing to all retaliatory acts
Just this
in
one.
total, but this particular one, we don't have an opposition to that.
February the 16th of 2015.
Correct.
Okay.
I believe, quite honestly, I believe there's a couple others from January 10th involving the same alleged victim, houses associated with him being attacked, and we don't have a problem with those either.
There are other retaliatory shootings, and you will notice.
Let's deal with them before, as they come up. Okay. All right. Can we deal with, so 13 is no objection. 14 alleges that on 10/27 of 2014, not 15,
Right.
there's an armed robbery, aggravated assault, arrest of Trontavious Stevens, arrested with red bandana in his right pocket, YSL tattoo on his side, Cleveland Avenue ROC crew on his hands, told Detective Mark Belknap that he, Stevens, is a member of ROC raised on Cleveland, but that they no longer go by that name, instead they go by YSL, which first stood for Young Slime Life, but they had since changed that name to Young Successful Life after his friend Jeffrey Williams gained more popularity.
So Judge, this act falls into a similar category as the one that we just discussed. Neither of the defendants currently on trial before Your Honor are directly implicated as it relates to the crimes that police were investigating allegedly committed by Mr. Stevens. However, since it was not one of the overt acts listed in the indictment, we just wanted to make sure that the defendants were aware that this was evidence the state intended to seek to introduce. Mr. Stevens is a person who had earned a guilty plea, who has signed a proffer, and we do anticipate calling him at trial. I believe that one of the components of the proffer actually addressed directly or indirectly this incident. So, with the proper foundation and all of that, the state does intend to introduce this evidence as proof of a material element of the crimes alleged in this indictment. So I'll stand down until the court permits me to respond to any arguments by defense.
Okay, Mr. Short or Mr. Steele, anyone else?
I do, Your Honor.
Okay, go ahead, Mr. Steele.
So, Your Honor, if Mr. Stevens is truly going to be called and decide to testify as a witness, then obviously he can be, other people may have objections, maybe I have an objection, but I would assume that the court may let in anything about YSL or rock crew becoming YSL or something to that effect, and we can cross-examine him.
Well, Civil Foundation, yes, sir.
So I just think that's just typical testimony. I would be objecting if it comes from Detective Belknap, because obviously that is Confrontation Clause information. As far as the armed robbery itself and aggravated assault, I would object. I don't know much about it. I'm not saying I did not get it in discovery. I can't place it in my mind right now. But unless that's tied to furthering a purpose for this trial or furthering criminal street gang activity as alleged in this indictment count 1, then it would, I would object to it unless it's being used somehow to impeach Mr. Stevens. And the only way to impeach him on that would be the prior conviction. You don't get into the specifics. But I would take that up as the trial progresses. I'll make objections. But I don't want to concede that part of that notice. If I didn't make myself clear, I apologize, but I'm just saying I probably don't have an objection to the second part of it. I more potentially have an objection to the first part of it. I'm making this up. If Mr. Stevens went out and his girlfriend was with another man and he armed robbed that man and committed aggravated assault on that man, I don't know why that would come into this trial. So that's what I'm saying.
Okay, thank you, Mr. Steele. I'm going to admit it, subject to foundation and further objection, but it'll be admissible. Assuming the state can lay a proper foundation in regards to it. Mr. Stevens is going to testify. Okay? All right, and number 15.
Your Honor.
Yes.
That last ruling is conditioned on Mr. Stevens actually being witness. Is that true?
Yeah, because and also maybe potentially Detective Belknap, but depending upon what's elicited or solicited from either one of those two.
No, I said this, that you don't have without seeing a tattoo possibly, that's one thing. I see.
Yeah.
Okay.
All right. And number 15 is the 12/24/2014 aggravated assault. Photographer attempting to take a picture with Jeffrey Williams was shot by a YSL member present with Jeffrey Williams and Martinez Arnold, among others.
Yes, Your Honor. So this was an event that happened at Midtown Cinema. No one was arrested. Law enforcement officers responded after calls were made regarding a shooting at the location. They spoke with witnesses who are included on the list of names. The state intends to call at trial. I specifically have spoken to the person, one of the two people who was shot, and I intend to call that person. Judge, this is an incident wherein someone attempted to get a picture with Mr. Williams, and Mr. Williams was flanked by other members of YSL. A person who was attempting to get a video of Mr. Williams and the interaction, in fact, captured a still shot of the parties present. Subsequent conversations with law enforcement revealed that the person directly to Mr. Williams's left was the person who fired that shot. And I believe, looking at that, I don't want to misspeak, but I believe that was Mr. Arnold. I will confirm. However, Your Honor, the point of it all is that these are people who stand ready to act on behalf of Mr. Williams, the photographer. In that particular case, he did not wield any kind of weapon. There may be an argument that, they were acting to protect Mr. Williams, or maybe defense may claim it was some kind of mutual combat. I don't know, but nevertheless, the state's position is that those are matters that go to the weight, not the admissibility of the act itself. So we would ask that the court allow the state to introduce, if the state so desires, evidence of this particular act occurring on December 24th, 2014.
All right, Mr. Steele. Excuse me.
Yeah, it's Christmas day before Christmas. It's December 24th, 2014. This is located at Midtown Cinema. The person shot, one of the persons shot is Ms. Reed, R-E-I-D. I have no reports or statements in discovery by her at all. There was another gentleman named Mr. Grimes, G-R-I-M-E-S. And this cinema is at 931 Monroe Drive. There's a large crowd. Allegedly, Mr. Grimes wanted to take a picture with Mr. Williams. He was warned, allegedly, not to touch Mr. Williams by an unknown person. Mr. Grimes and this unknown person got into an argument where they started pushing and shoving each other, and a firearm was discharged. Nobody says it was Mr. Williams involved at all. Mr. Grimes was shot in the upper thigh, in his left upper thigh. Mr. Grimes said he did not know who shot him. I did not get this notice until September 26, 2023. It's under 418. There's a notice that's on the state's witness list. That notice is late, as I cited to the court, the cases and the statute.
Can you interview this witness?
No.
Remember, the state said they were ready for trial November. Okay, I'm having internet issues. Hold on. Okay. Am I back? Can you hear me? There is a storm outside, and I don't know if you can hear me or not. I'm having a severe glitch here. And if you didn't, I'll say it again. What was I saying? Yes, the state said to the judge and the defense, we are ready for trial in November last year. And this new allegation was brought in September of this year. They have piled on and piled on and piled on during the entire jury selection. And this judge keep allowing it in. November last year, there were 79 witnesses. Now it's 737.
This is somebody I need to interview.
Okay.
In addition to that, there's a video of this incident that law enforcement officers looked at. This is Officer King, K-I-N-G. That night, he reviewed the video of the shooting. It had to be exculpatory for Mr. Williams. Mr. Williams was never arrested, indicted, charged at all. In fact, nobody was arrested, and it appeared that it was some justification. I have never been given that video. That is exculpatory information to allow this in. I've never
Has
gotten
the video been provided, or does it exist, Ms. Love?
Yeah, I want to be very clear. There's no video that we have or that I'm aware of the Atlanta Police Department has, and Mr. Williams has been on notice and apprised of the circumstances of this incident long before now. Actually, I think in September of 2022, he was provided at least a summary of this incident. I will confirm looking through my records, but certainly before more than 3 or 4 months ago, he was provided that, and we've never been asked for that particular video, and we don't have it in any event. So the fact that there is no video at this time should in no way factor into the court's determination as to whether or not this incident is admissible, but that's for the court to tell us parties. But we do not have a video. I believe that Mercier or King, if Mr. Steele is correct, pulled some footage. I wholly disagree with the notion that it's exculpatory. I understand that Mr. Steele is an advocate for his client, but I disagree with that entirely. And we would just ask that pursuant to and subject to the proper evidentiary foundations being laid, that the state be allowed to tender evidence of this act as well. And to be clear, we are not saying Mr. Williams shot anyone. The witness is not going to say that Mr. Williams shot him. So I don't know why that distinction was made when Mr. Steele stood, but we didn't say that.
Are you going to call Mr. Arnold?
That's not his picture, by the way. If you want it out, that's not his photograph.
We're going to call the witnesses who were there.
Well, Mr. Grimes.
Right.
Okay, so let's assume that Mr. Grimes testifies about what he testifies to, but are you going to get into this particular incident involves YSL members?
Yes.
Okay.
And from that, we have law enforcement testimony who were 1 on scene and 2 who aided in the ensuing investigation into the matter itself.
Your Honor, I don't have a video. The video existed. It's in a police report. It was watched by the detective. No arrests made, and it was found to be a justifiable shooting potentially. That's how it reads in the report. In addition to that, I didn't get notice on time.
Well, yeah, Mr. Lopes telling you got it in 2022 plus. Here's the other thing.
Where's my notice?
But here's the thing, Mr. Steele. Right, even though you're claiming it's late at this point in time,
Extremely late.
arguably, I'm going to give you some time to kind of look at it. So if you haven't interviewed this witness, I'll certainly allow you to do so. You can put him on the list of folks to given the ban period of time, the time that the court told you indicated. And once you've interviewed the witness, then I'll defer ruling on for the time being. So, but we can.
What's the purpose, Your Honor? This is not 418 evidence. What's the purpose?
It may be admissible for other things.
Right.
I mean, so
I'm not trying to be. What is it that Mr. Williams is around people who may have been justified in shooting?
Okay, here's the thing. If other people were going to testify that one YSL members were there, and that
who's going to testify?
I don't know. I mean, that's what she being Miss Love is telling me, that there are going to be other people that will testify that these particular individuals. Do we know who shot the photographer?
No, that's the whole point.
Your Honor, we do have the person that is identified. I spoke with law enforcement, and the person identified in the photograph, standing to Mr. Williams' direct left, is the person that did. And Mr. Steele was being so kind as to correct me as to who that was. But the state has alleged throughout this trial that people act on behalf of Mr. Williams. They're willing to shoot on behalf of Mr. Williams, and we're just alleging that.
So Mr. Steele, I'll defer until you had an opportunity to talk to the witness, and then I'll make a decision at that point in time.
When is it too much for the cup? I mean, this is December.
Okay, Mr. Steele, we've had the same argument. You've had made the same assertion over and over again. The state's got to be able to prove their case. You got to defend your case. I understand that, but I'm going to remedy the situation by allowing you to interview the witness. And then if you have any further argument at that point in time, I'll hear at that point in time. So I'm going to defer at this point.
I understand, but
it's the best I can do at this point in time. I understand your concern.
There's no prosecutorial need. Their whole claim is
you don't get to determine how they prove their case. I mean, that's part of their. There's it's subject to a cumulative objection. The case law, I think, history is pretty replete with examples of the state gets to unless it's just overly repetitive or other things.
It is.
But I can't make a decision until evidence is presented. I can't. I mean, yeah, they've got a lot of stuff to pick and choose from, Mr. Steele. So to your point, I think that's probably one of the challenges in this case. But until they present this stuff and it gets in and I kind of look at it and evaluate it in context, I can't make a ruling on it at this point in time. But I'll defer at least until you get an opportunity to talk to Mr. Grimes. And and of course, it's subject to additional foundation, okay?
I will step back, and I wish everyone a happy holiday. But I will say this, Your Honor. I get discovery late, I get witnesses late, I get the notice late at some point.
Okay, and you've made that argument very, very well. And I'm trying to kind of deal or fashion a remedy that will be fair to all of you. I'm going to take that up.
No. You don't have to be fair to everybody involved. Jesus Christ. You don't have to be fair to everybody involved. The state is producing pure garbage that they want in. And you just sit there, you spineless piece of garbage.
As I see fit. So that's why I'm going through the exercise I'm going through right now to make sure that you get to talk to these witnesses and perfect any other argument you may have. So I understand that. I'm sensitive to it, but I made my ruling.
No. They brought forward this 2021. So the RICO charge is very new. That case that she is referring to, in that police report, they are referring to that it might be a justifiable shooting. No charges brought. You have everything you need to know, Judge.
Okay, thank you, sir. Thank you, sir. All right. So, Ms. Love, if you will prepare a suitable order thus far, saying that I have deferred ruling on the incidents on 5/12/2013, I am going to admit, subject to foundation, the incident involving on 9/11/2013, that there's no objection as to the incident involving on 2/16/15, that I'm going to admit the 10/27/2014 incident subject to foundation, and that I'm going to defer ruling on the issue of the 12/24/2014 until the this is interviewed. And I'm also I'm going to also you could also put in the order that the witness on for the 5/12/2013 incident needs to be interviewed as well. All right, and of course, Monday. Yes, Mr. Steele.
I thought the court previously said that not only would we get the witnesses that are upcoming, and both sides have to do that, but also any other recordings, documents subject to, issues that you wanted to take up so we don't waste the jury's time. I did not get any of that. So if the state could please just send me whatever, or if they agree to what I'm saying, I believe that was your intent and your order. We can have that too. I appreciate the witness list, but it's not going to help us too much when I say, the state's about to put in whatever, I don't know, an exhibit that I've never seen before, or it's inadmissible, and then the court's going to say, I thought you guys took care of it.
We'll have that. We'll have an exhibit list ready for council. For the release in. Yeah. I'm sorry, Judge.
By what time and date, man? You think they could get it this Friday? At least for the people you're gonna call this coming week through Thursday.
Your Honor, if we could be permitted to, until Monday, given
No,
the availability of resources,
You have
I don't think that we would be
years.
tendering anything that there is much contention about. I will.
This is what the state prosecution has done this entire time. They don't want to give anything to the defense until the absolute last minute. How is this fair, Judge? You just said it. You were about fairness. Is this fair? No.
View our case as it stands to make sure that I don't think that that's the case, but if the court can permit us until then, that would be most beneficial. But he's asking for the list, not the. No. And I think that the request is for the list, not the physical evidence.
Because whatever, just to make it known, that's my point. When I send you, it's easier to send the actual document. So it is.
Let's just say by Friday you need to submit. Friday at 5, you need to submit whatever it is whatever it is. Identify and either point out in discovery or send them a copy of it that you intend to introduce at least for the following dates of 27, 28, 29, or 30 November.
How is this fair, Judge?
Okay, we good? That's that?
Yes, thank you.
All right. Now moving on to the last two items of business, the motion to exclude some screenshots.
We have not had the opportunity to respond to either Mr. Nichols' motions or Mr.
I'm gonna do it orally at this point in time.
We haven't even had the opportunity to view it, literally.
I'll tell you what, I'll make it very easy. I'll exclude it.
We're just asking for time. Those two pieces of evidence.
I don't have time at this point in time. It was filed at this point in time, so you got to respond to it now. Okay, because I don't have time. We're going to trial on Monday. We're not coming tomorrow. So I'll just have to deal with it the best way I can at this point in time. So I'm not trying to be difficult. I'm just telling you that's the only other option I have at this point in time.
You hear? State tried to, I haven't had the time to review it, blah, 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 blah. Finally, the judge grow a pair of balls. If you're not this hearing on yesterday, the 21st, list of what was going to be heard was ruled on, I think, somewhere early October. State had months to prepare. And here they are trying to, please, Judge, let us wait a few more moments. Finally, he grew a pair of balls.
Just give us one moment.
Hi, Anonymous. Welcome to the shit show.
Where are the screen grabs and the subject of the motion?
Does the court, or will the court permit counsel for defendant to just provide us with a courtesy hard copy as we speak?
If he has it, yeah, sure.
They don't have a hard copy, Judge. They were in.
Did you file it with your motion that was filed on November the 15th of 2023?
I don't know, I don't have that. I was not here to argue that. But they came in an email from Ms. Hilton dated Friday, November 3rd, 2023, at 1:47 p.m. So if Ms. Hilton can pull up her email.
All right, well, let's see if we can find it.
I want you to see it.
Attached to that.
This is how late she files discovery to the defense. November 3rd.
Does it relate to the screenshot? What day did you come out? November 15th?
I'm sorry.
On November 15th. Would you mind ordering a copy of it? You said you recorded. Sorry, your motion.
Yeah, so, set the result.
She said your motion. Okay.
She emailed it to me about 4:24. And maybe it's a game.
I just forwarded the exhibit.
There's, if I'm looking at this correctly, there's 1, 2, 3, 4, 5, 6, 7, 8. All right, probably less than 15 grabs. You want to share your screen map? Can you put them up and we'll just share, I'll just address them one by one?
Yeah, sure,
All right, okay.
Yeah, please write something in the chat. Keep the chat going. There's emojis for you. YouTube likes an active chat.
Okay.
Let's see.
I'm just asking for sharing capabilities.
You should be able to have it now. If not, let me make sure.
State response, so whenever the court tells me, I will endeavor to respond.
What's that? I'm sorry.
I think that the court asked prior to us breaking just now. I think that the court asked what the state's response was to Mr. Harvey's motion. Whenever the court tells me it's time, I'll get up and respond.
Oh,
Okay.
so you are capable.
I believe that, let's see.
How about that?
Specifically, I got your motion, and I'll go ahead and acknowledge that I have seen it. But is there anything in regards to the motion that you'd like to specifically point out?
Well, the only thing that I would point out to start with, Judge, is that under 901, the state has the burden of proof as to the authenticity. That's on the proffering party, and there's no presumption of authenticity. So the first issue is not my burden, it's on the proffering party.
Yeah, it's foundation.
And I would respectfully reserve my opportunity to respond.
Okay. Is the state going to be able to lay a foundation for the introduction of these particular screen grabs? If you could kind of give me kind of an orientation of the foundation and or their admissibility for what purpose?
So, Your Honor, the state's position at this time is that this is a premature matter that is not yet ripe for the court's consideration, given that we've not tendered it. We've just provided it as part of discovery. If at the time that
you've had that
during
for
trial, we
years.
consider the evidence, having laid the proper foundation, I believe that would be the time that the matter is ripe for consideration. As to, what I'm looking at in the motion is they're arguing that we cannot lay a foundation. We cannot prove its authenticity. We cannot do all of these things. Well, those are a lot of assumptions on the part of the defendant. And we don't, at this time, the state doesn't have to tell them, lay it out for them how we're going to prove or how we're going to get this evidence in. If we don't lay the proper foundation, if we don't meet all the requirements for the admission of evidence, then they can object. It doesn't get admitted.
Subject to a proper objection.
Right. And so I think that this issue is nowhere near right. I don't know if it's people are vigorously advocating for their clients, so I'm not going to fault anybody for that. But to somehow say that evidence should be excluded because they don't know how we're going to get admitted, it just does not rise to the level of ripening the matter such that we can even address it at this time.
All right.
Well,
And we should.
Mr. Harvey, I'm inclined to agree with the state in terms of the foundation, because it's not yet in terms of it may be subject to some objections that you raised in your motion, but until the state lays a foundation, I can't rule upon it yet.
Well, that's my first objection. The second objection, Judge, is let's, for example, look at the first screenshot that they gave us.
I don't know which one you're talking about.
And Your Honor,
Well, the first one that's up there.
as it relates to,
Let me see. Let me see it. Oh, okay. All right. So
Yeah, Ocean Drive, South Beach. No date, no time, no number, no nothing. What's the probative value of this?
don't know yet. Don't know what the state's going to offer it for.
There's-
I mean, look, it might be they introduce a witness that says, "Hey, we went to South Beach, and here's a picture of me and your client." At that point in time, yeah. I mean, so, or if somebody says, I mean, I interview for any number of things, Mr. Harvey, but I can't really determine at this point in time and rule upon objection until it's offered for a particular purpose that meets an element of proof or foundation's been laid.
It's irrelevant on its face. It's
I
irrelevant on
need to decide that. I think it's too early for me to decide that right now.
All right, well,
And I'm not going to at this
I'm
point.
gonna-
So I'll note your objection for the record.
I know you will, because it is on the record.
I understand that.
But it's going to require an out of the presence of the jury hearing to see if a foundation can be laid prior to getting before the jury and trying to do it and talking about each one of these things. What is that? Where did you get, so I'm requesting an out of the presence hearing to see if a
I'm
foundation.
going to have to wait and see what happens on that. Okay. Because, and I'll take, if you prompt me as to that, Mr. Harvey, I will certainly, depending upon it also depends upon what is offered and who is offered. But I'm not going to take every witness to determine whether or not there's sufficient foundation. I don't have to do that.
I disagree with you.
Okay, we're gonna have to disagree on that. If it comes to the point where I need to put the jury out for me to consider that, I will. But I don't have to do that for every single witness.
Oh, I don't think you have to do it for every
For
single.
for a predetermined reason. So I have to wait and see how the state presents its evidence, what they present, and like I said, please prompt me at that time if you think it's that time. Or hey, we're gonna get into this issue and judge.
I could bet money that the state has no idea whatsoever how to introduce this as evidence. They are just piling crap into this case and then take it as it goes.
I renew my objection about that, and I'll consider it at that point in time.
And that's fine. I'll be sure to prompt you.
I'm sure you will.
All right.
Okay. All right. So I will defer ruling on that until a foundation is attempted to be laid or is laid in that particular situation. Okay?
thank you, Judge.
All right. Okay. Mr. Matthews, you have a motion limiting on behalf of Mr. Yui in regards to a statement.
Yes, Your
Do
Honor.
do you have a copy of the motion, sir?
I do have a copy of the motion, Your Honor. Just need to get a good email address to send it to you. Your Honor.
I'm sorry. Can you email it to everybody, please, sir?
Sure.
That'd be wonderful. Thank you.
Yeah, this is the state's endless fun at play. Put everybody in jail, wait for some of them to plead out, then introduce evidence and discovery as late as humanly possible, and have a judge that has no spine. While simultaneously paying the defense attorney a grand total of $15,000 for the entirety of this trial.
Have you sent it, Mr. Matthews? I'm just checking.
Is the court waiting a copy of the motion?
Yes.
Yes, I sent it. You should have it, Your Honor.
All right, sir.
And that because the
And, Ms. Love, you said the order for me to sign
investigators,
it.
the police, the prosecution back in 2012, 2013, 2014, 2015 couldn't get a case together. Incompetence, I don't care. This is so stupid.
Ms. Love.
They were working on that, and
I don't know.
I'm just gonna check and make sure they have it.
Well, I'd like to sign it before I leave
Okay, I have it.
momentarily.
And Ms. Love.
The court just authorizes the court. Thank you.
Hell, everybody else signs my name, so why not?
Can you send it to everybody else? Thank you. Hopefully the easier ones. Number
All right, sir. Correct.
Yes, Your Honor. I'll be very brief. I'll start with hopefully the easier ones. Number 6, Your Honor, it says in reference to a statement. Well, first, the context. Mr. Marquavius gave an interview on November 24th, 2020.
Yes, sir.
And during that Mirandized interview with Detective Henderson, he began to have a conversation with Detective Henderson. And these are the points that I'm bringing to the court's attention to ask the court to determine that and this is in the event that the government decides to use that interview in its case in chief. So in the event they decide to do that, I'm asking the court to consider that in paragraph 6, where Mr. Huey makes a statement that he just paid off a traffic ticket and that his pretrial officer may have been aware of it. I would argue to the court that that particular statement is not germane or intrinsic to any overt act or count in this particular indictment. And because it's not intrinsic, we argue that in addition to that, it's not relevant and that it places Mr. Marquavius Huey's character into evidence, i.e. he paid off a traffic ticket, and secondarily that his pretrial officer may be aware of it. So I'd ask the court to determine that, that those are not relevant to the indictment.
Let's find out whether or not the state's even going to offer or evidence of that.
Your Honor, as it relates to the statements made by Mr. Huey, the state's position is that any and all of those statements that are statements which may be perceived arguably as admissions by Mr. Huey, we're not saying that they are the ones that have been identified as necessarily things we want to put in front of the jury. But what we are saying is that they are statements of a party opponent that should the state choose to have them introduced.
What's the traffic ticket and pretrial offer have to do with anything he's charged with?
Your Honor, as it relates to what Mr. Huey.
Because if I'm saying correctly, Mr. Matthews is saying, he's saying that particular portion of the interview may inadvertently put his character in issue unless it's related to something that you're going to prove.
So two things. One, as they relate to matters like, I received a traffic ticket. That is not the type of act that courts have considered prejudicial to the defendant. He is charged with much more serious crimes. So those types of things that may be interspersed throughout the statement that Mr. Huey gave are not necessarily things that we're even seeking to put before this jury. But more importantly, Your Honor, depending on how cross-examination goes, depending on what is brought out by Mr. Huey when he questions on witnesses, some of this may be relevant, none of it may be relevant. But Your Honor, we don't want to be prematurely precluded from introducing evidence. What we can do and what we will do is at the point where we will seek to introduce it, if we choose to do so, we would ask the court just be giving us a moment and an opportunity the day before to say, hey, this is what we're about to do. And at that point, I think it becomes right. But at this point, I think it is not right for the session. It is premature. They're asking the court to exclude the defendant's statements.
No, just a statement, if I understand correctly, Mr. Matthews, about the traffic ticket and references pretrial officer.
That's correct.
It's just that, it's not the other statements?
Well, no, I'm cherry picking right now, Judge, because I'm going through what is easier for the court's determination to the more challenging ones in the body of the motion.
And so we haven't even decided yet that we want to even play that statement. So I
You don't know whether or not you want to play the statement at all?
No,
Okay.
no, it just depends on how things go.
All right, let me do this then. I want to defer that until if the state decides they want to introduce it. Then at that point in time, Ms. Love and Mr. Matthews, I'll revisit the issues of whether or not it's his statements.
Whether or not something is more.
Whether not statements, or if you're not going to introduce them, then I don't have to rule on them.
Right.
If they do, then I'm going to need to make some, you're going to need to tell me what purpose that the statements come in for.
And then, Judge, there are about 4 or 5 other statements within that motion that we will address at that time.
Right.
Well,
And so,
I was just trying to do it easier.
Was he okay?
so
Was he arrested on this particular item, this particular incident on 24 November 2020?
Yes, Your Honor.
Are there any overt act? Are they related to any overt acts as in the indictment? Does this 24 November 2020 incident, does it involve any of the overt acts or counts on the indictment?
Yes,
indeed it does, Your Honor. The stuff that was found, this
Well,
is stuff that was, no, let me explain this.
Okay.
The items found in his home are the things from the armed robbery of Chandler Durham.
That's right. Okay.
That's
I'm
one of
going to
the
wait until they lay a foundation, Mr. Matthews. As soon as they lay a foundation, then I'll take up this issue.
because we will,
Yes.
yeah.
Because they may be
Audio is
relevant for
better.
a reason. So let me
Let
just,
me know
so again, I'll
if
invite
you
you before that comes
have
up.
and I will
Depending upon what's
let it
been
down.
presented, I'll then re-engage on this issue of the motion in limine. Okay?
That's fine, Your Honor. I don't believe it was an armed robbery of Chandler Durham.
I'm sorry?
I don't think it was an armed robbery of Durham. I think it was a theft by taking of a vehicle.
Okay.
Okay.
All right. Okay, I think
you, Your Honor.
You're very welcome, sir. I think at this point in time, have you got more yet, ma'am? Because I think we have exhausted the business for today. So I'd like to sign that order.
Okay.
Yes.
Just pertinent to your last analysis, if, and I don't know what Mr. Huey will do, but if Mr. Huey does not, I'm just using him because of his statement to law enforcement, he does not testify, I'd like to put everybody on notice. I know I've spoken with the prosecutors. There's some issues. It's not a admission by a party opponent as to Mr. Williams because it's a conflict. That's a statutory. This is a
No, but
conflict.
the state has to prove against different people, different things. So it may not be admissible. I don't think she's asking that Mr. Williams, it's attributable to Mr. Williams.
I understand.
But it may be attributable just to Mr. Huey. So to that extent, and then, you all will have to, kind of argue or educate as appropriate at the time that it comes.
Well, Well, I've done this before with court, and you said yes. It's everything like if somebody mentions Mr. Williams, it's excluded. If it's appropriate to be excluded. But what I'm saying is I will be asking for a jury instruction. So I'll give it to you, the jury instruction I request, but you know
That's early. You're
that
welcome.
this could not be used against Mr. Williams at contemporaneous with the statement. That's why I brought it up.
That's way down the road. I'll take that up when we get to it, Mr. Steele. Okay. I certainly, you know, when we have charge conference and you submit your charges, depending upon when evidence is presented, I'll then consider it at that point.
Okay. But I'm saying a limited jury instruction before the statement. Like
Now you talk about limiting instruction in regards to what?
like, let's say Mr. Huey's interviewed by law enforcement and makes a statement to law enforcement. I can't cross-examine him. That statement is confrontation. So
But if it doesn't apply to you,
that's what I would.
if it doesn't apply to you, then if it applies to somebody else, why would you want a limiting instruction? Why would I have to give one?
Because that way the jurors know it doesn't apply to me.
But you're going to argue that.
Yeah, but I'd rather have.
No. No. I mean, unless there's some legal reason for me to do that, Mr. Steele, I think that I'm not inclined at this point in time, not to say I won't do it, but I think it just depends upon what the state offers for what reason.
I think Rule 105 speaks to that directly.
24 dash what?
Whatever it is, 4105.
24 dash what?
And 105 speaks to the request for an instruction when evidence is admissible against one party and not another party. So I intend to go out to trial, ask the court to read 105 instructions.
That would be one of the defense attorneys that took on one of the defendants.
Your Honor, I believe that it may not be inappropriate for the court to give a limiting instruction when a statement is being tendered against one party opponent and not the others. So at such time as that circumstance arises, we would not have any objection to an appropriate limiting instruction. We think that that keeps the record and the facts before
That's
the jury.
fine. I mean, but yeah, I understand that. But what I'll do is whoever wishes the court to go ahead and consider a limiting instruction, if you please draft it, send it to the other opposing party so I can look at it. And please do it far in advance so I don't want you to just say, Judge, this witness is going to be called. I need a limiting instruction. I can't, and I got to pivot. So to the extent you want me to give.
Yes, Jingles has merch. This is the first item, and it's on my Teespring page. And GT just posted a link to it. Yay!
Please draft it, send it to Mr. Kearns early enough so I can go ahead and take it up like a couple of days prior, and I can look at it. We can source it. I can edit it, and then it can be given.
It should be flawless because if we're sharing information beforehand, our witnesses and exhibits, reports, et cetera, we would be on notice, and they would be on notice.
I don't have any issue with that, Mr. Steele.
That's what you want.
Yes, I do. That's what I'd like you to do. All right, Mr. Harvey, anything else about that? About the 105 limiting instruction?
Yes, sir. That's exactly right.
All right, so, but please don't do it like right before the witness is supposed to be called. I do need to have it a couple of days so we can go ahead and I can revise it or edit it.
Generic proposed.
That's fine.
Instruction.
That's fine. Just make sure it's sent to everyone who's in that particular category. Please, draft it so I can go ahead and look at it.
And we get the exhibits, so we can do that by Friday, I can send mine, and then the openings, I should send mine, maybe not out, but today's got to be together tomorrow morning, we can go out.
Everybody needs to have opening statements or whatever exhibits you're going to use by Friday at 5. Friday at 5.
Exhibits for opening statements.
Say again? For both, yes. Anything you're going to use in opening statements, PowerPoints, exhibits, need to be tendered to one another by Friday at 5. Friday at 5.
Trial starts Monday, and the judge just told state and defense, whatever you're going to use on your opening statements must be in the court by Friday at 5. So Monday, trial will start with opening statements, and I would suspect it takes all day, and I will stream that.
Thank you, sir. All right. Okay, you got that order yet, ma'am?
Judge, we were trying to get off of the list. I don't know if Mr. Steele has had a chance to take off the law enforcement and professional, but we were trying to just restrict it to lay witnesses. And may I inquire of Mr. Steele about that redaction of professional people? Okay. So we were working towards the same end. I was hoping that.
Can you all just look at it now? I'm gonna look at it so we can
Yes.
see.
The song lyrics will be subject to a hearing each time the state wants to bring them in, so that the defense can object to them due to foundation, relevance, stuff like that. So they are almost in, halfway in, so to speak.
So you can just come and look at it so she can delete out whatever it is. I can sign it and it can go.
So the list you gave me had professional people on it too.
That was a mistake. I don't think so, though. I think it was on the right.
No, but he said, so he was looking at it.
And that was on the lay witness. I just took your lay witnesses. That's what that first
Do
one.
you want to give me? Hold on, let me look at it again. Can you bring your computer over here, you know? Because so we have two screens. Okay. 'Cause, what is this? So you're saying
Mine
that
didn't
you
look like
took
that.
this?
Yeah, and I took your witness list and just copied the name and date of birth. That was what I sent to you in Word and PDF. Courtney sent it to you in Word and PDF. And then you wanted the restructure. And that's why I have these lines, these colors.
Okay, so what I'll do is say, hey, here's a list, but we're gonna do this first. The 70 that we
Yeah,
gave.
I don't really have a problem.
Okay. So can you look at
I'm
the
just getting
I'm gonna give, I'm gonna mess with house, but there's no piece of it in there. I don't know. Good. Records custodian.
Speed run.
Mr. Steele, did you look at the
Yeah.
ones from the state?
Yeah, the order is perfect. We read that earlier today. The state just wants to make the attachment, which is the witnesses, look and I said, oh, we've covered it.
What, and the other thing, Judge, is that I was just trying to make sure that the first witnesses that are provided for are the ones that we're calling in the first 3 weeks so that no issue arises if they have time constraints that don't allow them to get all of the witnesses to them. So I just want to make sure that the first ones that we are calling, that those histories are provided.
I think you indicated that to me earlier, so.
Okay, they are rounding up, it seems.
Okay.
Strip poker, I don't know.
All right, so he sent us over off of the proposing. Right. It's right here, description. All right, we have it. We're almost there. All persons. Okay, I got it. Okay, all right. I'm gonna document, Your Honor, with the court and the parties.
Via email?
Yes, Judge.
All right.
The defense has been arguing this since April. Give us the fucking discovery. And the state has prolonged and prolonged and prolonged until Judge set down the foot in October. He said, get them the discovery. And they still prolonged and prolonged and prolonged. And all of a sudden, we hear now that they turned some things over November 3rd. Because they were arguing, in April they said we will put it on 2 4 terabyte hard drives and give it to them. And then they argued, we will give it to them via Dropbox. And she blurted out that the reason they wanted to send it via Dropbox was so they could see which files they opened and when. And that was not allowed. So now, days before the trial starts, they are still sending over discovery. And this weak judge is all bark and no bite. Yeah. Yeah. Come on. End it. End it.
As well? You sent already as well?
I had a hiccup and I'm sending it now.
Tia, I won't be here in an hour because this stream is about to end in a few minutes.
But what I did to remedy the problem of waiting for our reformatting of that was say, the witnesses listed on Exhibit A are subject to the terms of this order. And that way you can go ahead and get the court signature on the order and attach the exhibit and send it over to legal counsel for the GBI and the GCIC.
Okay, what's on Exhibit A?
It is the witnesses that Mr. Steele has provided, minus things like custodian of records for Magic City or hers. Those are names that were listed. I was trying to go through and take that information out. But Exhibit A will consist entirely of the first 70 names that we provided as witnesses we intend to call in the first 3 weeks. And Exhibit A is important because I would like for them to get those criminal histories first.
Mr. Steele, does that agree with, what I want to do is I'll sign the order. You need to, I can print and sign right now, but you all need to pen and.
I think we're in agreement with the people that, the way that we're gonna do it, so.
Mr. Steele, any objection from you, sir?
No, Your
Is
Honor.
that acceptable to you?
Correct.
That makes it faster.
Come on. Please say you're done.
All right, Ms. Love, I'm going to hand this to you. Counselors, if you want to check it or have something, Mr. Steele, if you want to check it, bears that your two signatures, that is Ms. Love and Mr. Steele, in regards to the court's signing that order. So you're going to attach Exhibit A to it?
Yes, and
And when
this,
are you, when are you going to scan that to council? You can file it. You can email it to whoever it is your point of contact, but I'd like you to file an order under seal.
that was what I was getting at. I had
Okay.
to prepare that.
Just make sure that sure that's Mr. Steele, but when are you planning on sending that to council for the GBI?
I'll email it before noon tomorrow, probably tonight.
Can you send the court a copy and the parties a copy when that is done?
Absolutely.
Will that be sufficient, Mr. Steele?
Correct.
What about anybody else? Is there anybody else who has any specific objection or concern or comment about that? Or is everyone in concurrence that that would be a suitable resolution or plan for the GCI season that we discussed earlier?
And so that council knows, I have included in the order that counsel for defendants currently on trial before this court are permitted to review and share, but only people who are currently on trial
Okay.
for this court.
Yes, I anticipate getting the GCI and then dispatching via email to the lawyers.
Okay. All right. Okay. Unless there's anything else, I'll see everybody on Monday, the 27th. We need to be here and seated and ready to go so that we don't have to wait on our jurors to come. So make sure you're here about 8:30 or thereabouts and get situated and get settled. And we'll get everything started at that point in time for 9 o'clock. As soon as all of our 18 jurors are accounted for, we'll get started. All right.
You did say 9:30 though.
No, I said 8:30. You need to be here. We're starting at 9.
I heard it's 9:30.
All right. You heard it. No more hearings before trial. Everything should be set and done. I will start my stream at 8:30. Just in case new shenanigans that has to be ruled on. And I can almost guarantee it will on Monday. Thursday, Thanksgiving, I might put up a video. Friday, I'm going to do my dramatic reading of Young Thug lyrics. So watch out for that. Subscribe, give thumbs up. Thank you for being here. I'll be sending you off to Lawyer You Know, because they are about the Murdoch trial. And Miss Becky Hill's son, who is the head of tech over something in that court, has been arrested and charged for wiretapping. That could be interesting. Yeah, 8:30. That when the 8:30, that your time zone, Eastern Standard Time. Okay, thank you all for showing up. Thank you so much. I'll see you all here on Friday for my dramatic reading. It will be amazing. And have a good Thanksgiving, folks. My thanks is to my family, especially my dearest, who supports me in this new endeavor in my life as a YouTube commentator of trials and law. Okay, see you around. Bye-bye.